Hey. Hey guys. Okay. So I'm here. I see there's 10 people here. So you guys can see me, yes? I just finished in virtual court and threw on a sweater, something a little bit more cozy than a suit jacket, and I'm here. So I hope you guys can see me and hear me. I hope so. Let's see here. Oh dear. Let's see. Also, let me move my mic closer. You know how it is with me. It's always some trash when I'm trying to get started. Hey, hey. Great. If you can see and hear me, drop some chiclets. Hey, friends. Hey, Grace. Thank you. Hello, UK. Let me know where you guys are seeing me from. There it is. Okay, viewer activity. Not top chat. Live chat. Okay. Well, hopefully, YouTube, the back end of YouTube is a little behind, but you guys can see me. Michigan, Hawaii, West New York. Great to see you, Alana. Halifax, Nova Scotia, Canada. Hello, Austin, Texas. Hello, South Lake, Texas. Hello, Ontario. Is that Guelph, Ontario? We've got a few West New York, near Buffalo. Okay. Nice. I'm loving that I'm getting people here from Hawaii, from Durham, England. Hello, UK. Hello, Louisville, Kentucky. Ottawa, Canada, Oregon. Hello, England. Hello, Colorado. Hello, Argentina. I will try not to. Houston, Texas. Michigan. Tucson, Arizona. New York City, Jasmine, my hometown. Hello, Florida. Hi, guys. Hello, New York City. Hi, Los Angeles. Hey, Boston. Hey, Portland, Oregon. So as you guys are coming in, take off your shoes, like the video, get comfortable, get a drink. Hey, OPT. Vacaville, California. Puerto Rico. Hey, friends. Hope you guys are doing great. Ooh, I've already got a super chat. Look at that. And hello, Blackpool, UK. Julie Liffam, thank you for the $4.99 super chat. Sending out prayers to everyone in Florida dealing with the building collapse. Yeah, guys, let's talk about the building collapse right now. That is so horrifying. I don't know how a thing like that happens. Someone was saying that someone had a hypothesis online that it could be due to the frequent hurricanes that they get, that maybe the building just couldn't take all the hurricanes, the shaking and stuff. So that is so, so sad. And my thoughts are going out to everyone that's affected. Everyone that's affected. And I'm so, so sorry. And thank you, Judy, for bringing that up. I appreciate it. Hello, Oklahoma. Please make sure you take your shoes off, like the video. There have been structural complaints lately, says Laura. It looks as though the ground under the building caved in. Oh, imagine just being in your bed, sleeping, and having that happen. They said the building was about to have a major renovation on the steel and concrete. Oh, that's so sad. They knew the building needed help and they were planning on doing it since it's 40 years old. Oh. Hey, Runway. Thank you for the 10-pound super chat. I appreciate you. Hello and happy Friday. Guys, there was a building collapse in Miami, Florida, a residential apartment building, high rise, and just half of it just caved in the middle of the night while people were sleeping. Yeah. Yeah, my delay is short today. It depends, you know. I don't always know what the delay is going to be, but it depends. It's terrifying. Oh, someone's roommate used to live near that building. Oh my gosh, how scary. Oh. Well, guys, I thank you greatly for you being here. Hey guys. Hey Colleen, thank you for the baby chicks. Good evening, trans girl. Yeah, Gary said he'd want out of his lease. I think every single person would by right be able to break their lease and get out of there. It's not a safe place to live. I'm sure that's like an implied condition that the place be livable, habitable, and safe. You can't stay there anymore. Thank you guys so much. On our last live stream where we talked about Ronnie O'Neal, we got a bunch of new subscribers. So if you're new to the channel, welcome. I'm going to get right down into business. I always like to make sure. Oh, yeah, trans girl. Before I get to that, there was a bridge that collapsed right here in my area, the 295 bridge, or a bridge going over the 295. Or was the bridge a part of the 295? I can't remember. But either way, a truck was traveling on the 295. It was too high for the bridge. And he hit the overpass. It collapsed onto 295, which is a major highway here in what's called the Beltway. The Beltway connects DC to Maryland and Virginia. And basically a lot of like people that work for the government have to take that. So it was a major issue. Thankfully, no one was killed. Hey, Nicole H with the super sticker, $3.99. Thank you very much. Appreciate you very much. Thank you. Just trying to see if YouTube's back door has caught up to where we are now, because I like to keep that open so I can see your super chats a little bit better. The only problem with StreamYard, the only issue I have with them, it's very, very small, is that if I wait too long, I will lose my super chats. Yeah. Hold on, maybe I can find it here because I want to make sure I don't miss out on you guys. And then I like to be able to see what the super stickers are, and I can't really see them in Streamlabs, which sucks. Ooh, I think I got it. I got it. Look at Natalie figuring out technology. Who am I? Okay, this is not made for kids. We don't play none of those games around here. This is adults only. We talk about very adult things. And we want to do this. Might as well. Cool, cool. Save that. See, look at that. Azure sent me a $4 super chat. And if you're in the chat, you can see it. It's so cute. It's like a little coffee guy. And I want to be able to see that. So now I can. Wonderful. Then I have a $4.99 super chat from K-Rab. Thank you very much. Florida sits over the largest aquifer in the country. It's the reason why there are so many sinkholes in the state. Yeah, a lot of those sinkhole videos, which are terrifying, showing the ground just basically crumble. But did you guys see last year there was a big sinkhole that opened up on a street, a residential street in Manhattan? Thankfully, which, you know, Manhattan's an island as well, but thankfully there didn't seem to be anyone on the street. A bunch of cars went in, but no person. There were parked cars. $4 super sticker from Azure. Thank you very much. And Steve Arena with a $20 super sticker. Thank you very much, Steve. You're much appreciated. Thank you. And moderators who are here, first of all, before we even really get into things, please thank the moderators. They're so helpful. They don't only keep the stream moving. I want to do like a moderator appreciation or something. They do more than that. They do more than just, make sure that everyone's having a good time and no one's disrespecting anybody. They also make sure that I don't miss out on super chats. They also make sure that I answer questions that are really important that keep popping up. So thank you to them. Thank you, mods. Thank you, guys. Yeah, so yeah, she says in Trans Girl says that in the Netherlands, they pay a lot of taxes, but in return, they have safe roads. Yeah, in return, thanks, mods. You guys have a lot of things that we don't have, but I guess less taxes is a good thing. I don't know. Lord, I feel like I pay a lot in taxes, so I don't know. Hi, Runway with the 10-pound super chat. Thank you for thanking the moderators. They are the best. Let's get down to brass tacks. Okay, we're going to do that. We are going to edit this. All right, guys. So who are we going to talk about first? Are we going to talk Derek Chauvin first, whose sentencing is coming up today and will likely break while we're here? I'm not sure. Are we going to talk Derek Chauvin first, or are we going to talk Rudy Giuliani being suspended from the practice of law in the state of New York? Because that's where he's licensed to practice. He's appeared other places pro hoc vice, which is your license to practice in one state, and then another attorney will allow you to practice under their name for one particular case in another state, but you have to be licensed elsewhere. So his base is New York, and they have suspended him from the practice of law. He has an active law practice, but he's suspended now and he can't practice law. So which one do we want to talk about? Rudy Giuliani or Derek Chauvin? And then we'll talk about the other one afterwards. Okay, so I'm going to take a 11:30 Pacific Standard Time. Okay, Lil Numby. Okay, so I see Chauvin, Giuliani. Is Lil Numby Chauvin or Giuliani? I don't know. Giuliani, which is Rudy. And then when Chauvin breaks, we'll break into Chauvin. Rudy sounds easier. Giuliani first. Yes, awesome. Okay, let's start with Giuliani. Let me just go back, make sure that I'm good. Yeah. Okay, I'm making sure that you guys are with me. We're going Giuliani first. And let me make sure I spell things right. Okay. We're going Giuliani first. Talk amongst yourselves. Make sure your shoes are off. I don't like people tracking their dirt around my house. So that means that you like the video as you come in. Okay. Let's talk. Let's chat. See, look what I did. I'm always doing too much. All right, let me make sure that I'm on, you guys. Okay, I think I've missed some super chats, so let me just go back real quick and then we'll get started. Lori Zold. Why is this so small? Lori Zold. Thank you very much, Lori, with the $4.99 super chat. It wasn't a sinkhole. It collapsed from the top down, shearing at the elevator shaft. Seems like corrosion, metal fatigue, concrete erosion to me. Thank you, Lori. I don't think that person was saying that this was caused by a sinkhole in Florida. They were just saying that, for example, a lot of sinkholes do happen in Florida, which they do. But, that makes a lot of sense. Thank you for that insight. I appreciate you. I'm going to start with Rudy. I'm getting a lot of Rudy. Our boy has been up to no good. He's in trouble. Someone said Jabba the Hutt. The names. Rudy is a bit more lighthearted. It is. It is. That's funny. Steve Arena with the $5 super chat. Thank you very much, Steve. Thank you. So it says Rudy, 9/11 mayor turned creep. So mixed on feelings, guys. We're just getting started. So if you're just now coming in, I see that the amount of people watching has jumped up to 310. So please make sure that you like the video. I'm coming across a little fuzzy for some reason. So let's see if that fixed it. That could have made it worse. I'm good for that. I'm good for making it worse. I have 307 concurrent viewers And I have 100. Ooh, I definitely made that worse. Oh, Natalie, what are you thinking? Okay. Let's do that again. Hold on. There's a bit of a delay, so it's hard for me to tell sometimes what I've done. Come on back. Come on back. Let me see, because we really need to focus in on each other here. And I need you guys to be able to see me. And there we go. Okay, awesome. So I actually pulled up the opinion of the Attorney Grievance Commission of the state of New York. And it's very, it's more explosive than people understand it to be, in my opinion. Okay. This is just my opinion based on nearly or over 10 years of experience, right? This is just what I think. But I think that based on my experience as an attorney, we have our own grievance commission in the state of Maryland. We've all had to deal with them at some point in time, either for complaints or they've called upon us to answer a certain question, maybe regarding another colleague. Some people have had to report their colleagues. All attorneys have had to have some type of dealings with the Attorney Grievance Commission or whatever the body is that governs the practice of law or the ethical practice of law within the various states, right? So let's get right down to what the actual filing says. So I'm going to share my computer. We are going to share screen, and then we shall share. And then I am going to make me like this. Child, yes. Okay, perfect. This is what I want it to be because I want you guys to see me, but I want the screen to be bigger so that you can actually see like what I am talking about and my facial expressions because Lord, I can't ever control my face. That's why I can never, ever play poker. So let's go full screen so you can see. So this was filed in the Supreme Court of the State of New York, Appellate Division, First Judicial Department. The Supreme Court of New York is actually, oh, my video is ready. Okay, we can close that. Always working, always uploading videos and filming, always trying to make sure I'm giving you guys content when I can. Okay, so the Supreme Court of the State of New York is the lower court of the state of New York. It's actually the lowest trial court. So in the state of Maryland, the district court is our lowest trial court. And then our highest court is the Court of Appeals. Most people would think that your highest court would be the Supreme Court, but that is not in the state of New York. This is the Supreme Court, State of New York Trial Court, Appellate Division. So the Attorney Grievance Committee, ours is the Attorney Grievance Commission. Theirs is the Attorney Grievance Committee for the First Judicial Department. They are the petitioner. They have filed this petition based on the complaints that they receive. So just as like some background, you will receive complaints, the Attorney Grievance Commission of the different states, whatever they're called, because they'll all have different names. They will receive complaints basically saying this attorney did something wrong, and it's up to that body to determine whether or not the complaint is even worthy of a response. So in some states, no matter what the complaint is, they will demand that the attorneys respond to the complaint. Like the attorneys themselves have to respond to the complaint, and then they will decide, the grievance commission or whatever the body is called, whether or not they're going to pursue the complaint, ask for further inquiry from the person who filed the complaint, or if they're just going to close it out, right away, because they can do that as well. But in Maryland, they won't close it out without seeking input from the attorney who the complaint is made against. And a lot of the times when attorneys in the state of Maryland get in trouble, it's not so much for what they did or what the person making the complaint alleges that they did. It's more so because they didn't respond to the Attorney Grievance Commission. So that's usually what attorneys in my state get in trouble for, because we are mandated to respond to them if they say, and it could be the most ridiculous thing. It could be a person is complaining on you because you cut them off in traffic. You know, this person's an attorney. I saw that they had an American Bar Association or Maryland Bar Association sticker on their car. So they must be an attorney. I looked them up. I found them, and they're one of your attorneys, and I want them disbarred. And they'll have to say, please respond to this. And you will have to respond. Your failure to respond can lead to you getting reprimanded. In the state of California, I know, for example, that they do a preliminary review of whether or not they think that the case has any type of merit to it. And they won't ask for a response from the attorney unless they think that there's some merit to the complaint and it actually violates the rules of professional responsibility. And all it comes down to is it's not even about committing crimes. It's about the rules of professional responsibility. And those are laid out in various statutes. Like in Maryland, we have our own separate rules of professional responsibility that are promulgated in a statute. And every state does them differently, but that's what it's about, if you violated those rules or not, right? So the state of Maryland and California are different in that way. The state of New York is closer to the state of Maryland in that they won't close out the case right away if they don't get a response from the other party or anything like that. They're going to start their investigation. So they started an investigation based on the various complaints that they have received. So I hope that makes sense. They've gotten all these complaints, and they're saying that, based on these complaints, we have started an investigation into whether or not Rudy Giuliani should be allowed to practice law in the state of New York. Here is why it is extraordinary, because a lot of the times, if it's a serious enough complaint or widespread enough complaint against an attorney, there is a due process that's involved where the grievance commission will do an investigation into it. But in the interim, while they're doing the investigation, the attorney is still practicing law, right? They're still practicing, they're still earning money, they're still doing what they need to do, right? And the attorney grievance commission can be conducting investigation that involves the attorney, or they can conduct an investigation that doesn't yet involve the attorney other than the attorney's response, right? So while they're conducting that investigation, they very rarely take any action against the attorney themselves unless unless they think it's so serious that this person cannot be allowed to practice law while they conduct the investigation. That's how they do it in New York. They don't do that everywhere. So that's why this is so extraordinary. Most places, the investigation has to conclude, and then you get a hearing, right? You get a hearing in which you get to appear either before like an appellate court or a grievance commission hearing body, and they make it a preliminary, they make a determination on whether or not you are fit to practice law or you violated the rules of professional responsibility. Like they'll make a separate determination, and then there's graduated punishments or sentencings or remedies that can be placed on the attorney. Those remedies can go from, write us a letter telling us why you know that this thing that you did was wrong or outside of the rules and how you will not do that thing again. And sometimes they'll do that in situations where it's like the attorneys made some type of financial mistake, like say they deposited the money from their client instead of going into the client account. So we keep like separate client accounts for client money. Maybe they one time accidentally deposited in their personal account. Like it just was a bank mix up because you do your client account at the same account as your personal bank, and the money accidentally went to the wrong place. And somehow the attorney grievance commission finds out about it, and they will like say for you to respond, you can respond and say, oh, that was a mistake, I'm so sorry. And then they'll say, okay, well, write us a letter explaining to us like why you'll never do this again, and that you understand the rules of professional responsibility. That's like one of the lowest forms of punishment or remedy that can be imposed on you. And they might not even hold that against you on your record and say that you've been sanctioned. But then graduated from there, you have sanctions. And those sanctions include things like time limited suspension. So it'll be like, oh, you're suspended from the practice of law for 30 days. Another reason you can be suspended is like not paying your dues as an attorney, right? So you can be suspended, but that's not a disciplinary suspension, you know? It's just saying that you haven't paid your dues to be an attorney, so you cannot use your license for this period of time, but you didn't do anything like ethically or morally wrong, as long as you don't practice law while you are suspended, right? So another type of thing is like a longer suspension, 60 days, 90 days, 1 year, 2 years, 3 years suspension from the practice of law. So those have definite periods of time by which you're suspended. And then maybe to get back into the practice of law, you might have to do something in order to come back. Some people, it's just a flat suspension and then they come back. Some people, it's a suspension and then they have to like do something to show that they now understand the ethical rules. Depends on the state, depends on the situation that the attorney is faced with. And then the most severe punishment that's placed on an attorney for violating the rules of ethical responsibility is that they are disbarred. So when you're disbarred, that means that you are no longer allowed to practice law in that state. And some states will not admit you after you've been disbarred in another state. Like they'll never, like it's going to be really, really hard for you to practice law anywhere, but you can definitely never, ever engage in the practice of law in that state. So yeah, that's a pretty severe penalty. So what's so interesting here is that they haven't gotten far enough to determine whether or not Rudy Giuliani is going to be disbarred or not, but they were so concerned by what they found through their preliminary investigation that they did not want to allow him to continue to practice law while they were investigating him. He has not even gone to a judicial body yet, right? So he's not even gone to a determination of whether or not he's actually committed the allegations. There's no like hearing judge that he's gone in front of where he can say, I didn't actually do these things, right? But they're saying that the evidence is so overwhelming and the behavior is so concerning that we have to suspend you from the practice of law in the meantime so that you do not continue to serve as a danger to the public through your function as an attorney. And the misconduct in particular that they are alleging is misrepresentations of fact to political bodies, judicial bodies, and the public. So that can only be something that's actionable if it's under the rules of professional responsibility. And under the rules of professional responsibility, attorneys have a duty of candor to the tribunal, which is, that's the court, right? The judge, the jury, whoever is deciding the case, we have a duty of candor, truthfulness to them. We also have a duty to our clients, and we have a duty of candor to like the public. And if we are appearing in like political hearings, like say like before the Senate Judiciary Committee, or say that we're put under oath or anything like that, like if we're ever sworn under oath, on top of the fact that nobody can perjure themselves when they're under oath, we have the additional responsibility that we have sworn ahead of time when we became an attorney that we would be honest in all of these types of dealings. And if you're not, you can face suspension or disbarment. So that's why this is so significant. So I'll read to you a portion right here. They said, we conclude that the respondent's conduct immediately threatens the public interest and warrants interim suspension. So interim is in the meantime suspension from the practice of law, pending further proceedings before the Attorney Grievance Committee, sometimes AGC or committee. So they haven't even finished their proceedings yet, but they were like, emergency, alarm. We have to suspend this person right now in order to protect the public. So before I go into this, let me go back to you guys and talk to you because I can see that the comments are like kind of like blowing up and stuff. So let's go back. Okay. So let's stop screen and hi. Okay, so let me see if I've missed any super chats in the meantime. 492 concurrent viewers and 213 likes. That means that, my friends, you're not taking off your shoes as you come in. So please do. Please take off your shoes. Okay. So it's showing me no super chats. So I'm not sure if that's right or not, but I'm going to get right to the comments. Okay. I'm gonna get right to the comments. Let's see. Oh, see, they lying. Oh, yeah. Oh, no, they're not lying. They're telling the truth. They're telling the truth. Okay, so I'm back. So let's talk. Do I use light mode? Ew. It goes automatically to dark mode at night. So in the daytime, it's in light mode. And I need that because I can't see. Okay, so boop. Hey, Eva Roberts. Hey, everybody. How's it going? Okay, so hi, England. All right, guys, let me know. Shoes have been removed. Genevieve is following directions. Thank you very much, Genevieve. Okay, any questions so far about Rudy Giuliani and where we're at? So Tracy says, so this sounds like a slap on the wrist for his conduct up to this point. Further charges may come into play. This is not a slap on the wrist. That's what I'm trying to because I saw some people say that on my Twitter when I shared it on Twitter. And people were like, oh, so this is he's just suspended. It's just a slap on the wrist. It's not. No attorney takes a suspension unseriously. It's very, very serious to be suspended. That's number one. Number two, it is extraordinary for a attorney grievance commission or similar body to take action against an attorney before the proceedings have been concluded, before final determination has been made that the person has actually violated the rules of professional conduct, and that there's no lesser remedy that can be put in place to make sure that the public is safe, right? Because we interact with the public and we have a duty to, care for them, take care of them, make sure that we do not harm the public in our practice of law. Like, we don't have a Hippocratic oath like doctors do, but we can do a lot of damage and harm to people in our practice of law. People take us, they take what we say seriously. We have people's money in our hands. We have people's lives in our hands. We have people's freedom in our hands. So for that reason, it's a very high bar that's set on us that we have to daily overcome to not violate the rules of professional responsibility. And what they're saying here is that we haven't even heard from you yet, but based on what we have seen, you're not safe to remain a practicing attorney. And you got to remember, Rudy Giuliani, it's not like he's retired or something. He's older, but he's not retired. He still represents people. He serves as counsel, previously served as a personal counsel for the president of the United States. So to say that based on your representation of that client, you could no longer practice law is major before even, the case has been concluded. It's being suspended is like being disbarred in that moment. And what they're saying is that it can get worse from you from here. So he can be suspended now and then disbarred later. So I would say it's not a slap on the wrist. I would say a slap on the wrist is if they said, we want Rudy Giuliani to write a letter apologizing for lying or to admitting to lying or something like that. And as long as he does that, then we will not take any action against him. That's a slap on the wrist. A suspension is not. But thank you for that. That really is a good comment. Runway has a 10-pound super chat. Thank you very much, Runway. Do you feel like the press media has influenced the severity of the action taken? So they were very careful to say in the petition that no, that's not what it was. It was looking at the things that he said and the representations that he made in court, and then comparing that to what is actually factually known and seeing that those things are provably false. And he made those misrepresentations in court to the public and to political bodies, which is strictly forbidden by our rules of professional conduct. So it's not so much, it has a lot of popularity. Now, they received a lot of complaints. He probably received more complaints than any attorney in history in the state of New York because of the popular nature of it, because it dealt with the president of the United States and the 2020 election, right? So they probably got more complaints than normal. But I can guarantee you that if these same allegations that they found were uncontroverted, meaning there was nothing to contest them, that they found uncontroverted in the petition, were made against any other attorney would have been suspended in the interim. It's so bad what he's alleged to have done. That's why I was like always surprised during the actual campaign, like when they would, you know, play audio recordings of him in court being like, oh yeah, no, we have actual proof that you know, a dead person voted or something. And the court would be like, well, I don't have anything in the file saying that. I'm just giving a random hypothetical, guys. But he would make some type of concrete claim about voter fraud, how they had affidavits saying some type of claim, and the courts would confront him like, we don't have that in the court filing. Oh, I'll get it to you. Or, you know, oh, I don't mean that exactly, you know. And it's just like, it's one thing, we're not supposed to lie to the public, but, you know, lawyers are called liars for a reason. People think that, you know, we lie on default, right? I'll get to the super chat in a second. But people think that lawyers are just liars, right? But we are literally not allowed to lie in court. We're not allowed to do that. And if you're found, and that's not to say that lawyers don't lie in court, because human beings lie. And some people are bad people and just lie for no reason. But if you're found to be lying to the judge, that can be automatic disbarment. There are regular everyday attorneys. I mean, just like folks that are prosecutors, public defenders, you know, that get suspended or disbarred on a daily basis because they lied in court. A good example of that, do you guys remember that video that I did where the defense attorney was threatened to be held in contempt of court because she acted up on her client? It was saying that her client was mentally ill, but that was just because the client didn't want to take a plea. Like, he didn't want to go forward with the plea or do things the way in which she wanted. And she was on Zoom and she starts yelling at the judge and was like, I bet you I don't come back. That lady, she was previously a prosecutor in that county or in that state. I'm not sure if in that same county, but definitely in that state. And the prosecutor's office not only fired her, but she was also suspended because she lied and said that there was no particular type of evidence. Let's say a 911 call, right? She said there was no 911 call after the defense had requested it in discovery. And you have a duty to disclose once requested. And she said it didn't exist. And then later on find out that not only did it exist, it had been like handed over to her office or something like that. So that got her suspended from the practice of law. And that was just in one criminal case, just involving a 911 call. So repeated lying in court over and over again, misrepresentations to the court in multiple courts in multiple states. Yeah, that's going to get you suspended, you know, and could very well get you disbarred. But it's amazing. And I don't mean like amazing, wow, great, good. I mean, like, I am amazed that he has been suspended before they have finished making their determination. It does not bode well for his overall case. He's going to have to come in at the hearing. He's going to have to come in with some type of evidence to show that the statements that people believe are misrepresentations to the court, that those statements are actually true. Like, oh no, like, I did have a witness to say this. Not that he doesn't have to prove that voter fraud happened or didn't happen. He's going to have to prove that when he said they have a witness who will say this, they have affidavits that will say that, they were dumping ballots in the trash, and I have witnesses that will say they were dumping ballots in the trash. If he can't come in with someone to back him up on that, he's going to lose his license to practice law, because those are the type of claims that he made over and over again, you know? And it's just like, you can't do that in court. It's like, we shouldn't lie to the public, but it's not like a public, where was he when he was like at the like automotive shop, the Four Seasons? They were doing a press conference, right? It's not like a press conference. You're not a PR guy. You're an attorney licensed to practice law, who swore to uphold the truth. So when you step into a court of law, it's not about PR anymore. It's not about trying to spin a story. You know, that's why a lot of the times the PR guys are not attorneys, because they have to lie to the public on a daily basis. You have your attorney do your stuff for you in court, but the person who actually like does your press conferences is usually not your attorney, because we cannot lie like that, you know, and it'll come back to bite you in the end. Michelle Polk, $5 super chat. Thank you. No comments. Only want to show my appreciation. Thank you, Michelle. I appreciate you. You guys keep me updated for when Derek Chauvin goes live. So Colleen Moylan thinks that Giuliani will pay someone to say that. I mean, and that's possible, right? Like a possibility is that he will pay someone to say that. But you got to remember that person, like Giuliani, will be under oath, right? Subject to prosecution for perjury, because not only is perjury a stain on your like moral, standing with the public, it's a crime, So if someone's willing to take some money to be implicated in a crime, I guess they could do that, but they'll be prosecuted. And I am sure the attorney grievance committees usually have a lot of resources at their disposal. Those are okay. So the people running the local for each state attorney grievance or professional responsibility offices or whatever they may be, they're attorneys. They're attorneys with a lot of experiences. The hearing judges over them have been judges before. It's not a game. They're not playing with them, right? So in Maryland, the Attorney Grievance Commission, they send you if you get a complaint and they need to hear from you, or someone else gets a complaint and they want to hear from you because they think you might know something about it. It comes in like this white envelope with blue writing on it. And let me tell you that everybody that I know gets so nervous whenever they get one of those letters. So there's just like no way, because they have the resources at their disposal, 605 viewers. That's what's up. Oh, so 2:30 Eastern is when we have Chauvin. Okay, so that means that 1930 UK time. Thank you. Right now they're showing reruns of testimony. Sound the alarm when they get to the courtroom. Thank you, Amber Joy. You're great. Thank you so much. Let me stop yelling because I'm right up on the mic and I don't need to yell. I just have a really loud voice. I can't help it. Okay, so I'm going to take you guys back to, I'm missing a super chat. Sorry. Moshu Willow, $5 super chat. Thank you, Moshu. Hi, Natalie. Hi, Moshu. Doesn't the bar have something like that about integrity? Someone must have reported him. I'm late, so I may have missed it. Yeah, you missed it. Multiple people reported him. It's the rules of professional responsibility, the rules of professional conduct, whatever you may call them. It's not really the bar. The bar is just like kind of a colloquial term that non-lawyers use to think of like the body that governs attorneys, but it's usually not called the bar. The bar is usually some type of private organization that attorneys use for like networking, marketing, continuing legal education, things like that, listservs, those types of things. And it can be a resource for the public, but usually we're governed by, for us, it's the Court of Appeals of the state of Maryland is what governs us. And then the body that oversees attorney misconduct is the Attorney Grievance Commission of the State Bar of Maryland. And so they, in New York, have an Attorney Grievance Committee of the state of New York. And they determine whether or not they're going to investigate someone for misconduct. And here there were complaints that Giuliani was lying to the courts. So let's get to the complaints because your question is awesome. Thank you so much. Let's get to the complaints. We're going to share the screen and this and share. Boop. Okay, you can see me right here. Cool. Okay, so let's go here. So let's go to what the actual allegations are against Giuliani. But before we do that, so this is what I was saying about the rules of conduct. For us, it's the rules of professional conduct. For them, it's the rules of conduct. All attorneys who are licensed to practice in law in New York are subject to the rules of conduct, which establish a framework for the ethical practice of law and a lawyer's duties as an officer of the legal system. Violation of these rules may lead to professional discipline. The ultimate purpose of any disciplinary proceeding, however, is not to impose punishment for breaches of the rules of conduct, but rather to protect the public in its reliance upon the integrity and responsibility of the legal profession. So here, what the courts are trying to make, or what the grievance committee is trying to make clear, is that they want to protect the public. They want the public to know that you can trust that your attorney is going to follow these ethical rules. And if they don't, there will be consequences. So that's the framework through which I want everyone to think about this. This is not about Rudy Giuliani. It's about the public and the practice of law. That type of behavior, unfortunately, is seen to be almost like accepted within the community, that lawyers are going to lie and lawyers are going to do this and do that, whatever it takes to win or help their client. And it's just like, yes, we're supposed to do whatever it takes to help our client, but we have to walk this tightrope where we cannot lie to the court. We cannot. It is better to remain silent than to do that. And the public should know that when dealing with us. So these are the claims of misconduct. Only uncontroverted, meaning that there hasn't been anything to say that these claims have not happened. Uncontroverted, uncontested claims of professional misconduct may serve as a basis for interim suspension on this motion. So this means that he's been suspended pending the outcome of the full investigation and a hearing on the merits. In connection with this claim that uncontroverted attorney misconduct has occurred, the AGC relies upon the following provisions of the New York Rules of Professional Conduct. A lawyer shall not, these are the rules that all attorneys must follow, and the Maryland rules track very closely. I bring up Maryland in case you guys don't know, because that's the state that I practice in. Sometimes I'll bring up California because I appear pro se in California court, not as an attorney, but as a litigant representing themselves. And so I had to familiarize myself with a lot of the court rules of procedure there and the other types of rules. And I came across the rules of professional conduct in California as a result of that. And so I just like to be able to give you guys some examples of how it is in different states. So, like, it's always good to know, to compare and to contrast. So a lawyer shall not knowingly, meaning that this imposes a mens rea, a mental intent prong, meaning that it's not a strict liability professional responsibility. So just doing a bad act is not enough. You had to have known that you were doing it. So you should not knowingly make a false statement of fact or law to a tribunal. So a defense here for Mr. Giuliani, when it does eventually go to a hearing, probably on whether or not either the suspension should be elongated, the suspension should be stopped, or he should be disbarred altogether. One of his defenses could be that he didn't know that he was making a false statement. He believed in what the president was telling him, or he believed in what the investigators or whoever it is that they hired to help them with this case. He believed that. He believed the affidavits that were brought his way. He had nothing to do with the actual correction. And so he didn't know that he was making false statements of fact to a tribunal. Tribunal is just the court. That's a fancy word for court. In the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law to a third person. That's very broad. A third person, that can be just the public, okay? That could be the opposing party, the opposing party's attorney. That could be so many things. You can't make a false statement of fact, even to help to represent your client. A lawyer or law firm shall not, completely forbidden, right? Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Okay. So whenever an attorney is reported for this, dishonesty, fraud, deceit, misrepresentation, they can face punishment, basically, because they have damaged the practice of law and reduced the public's trust in the practice of law. And they cannot engage in any other conduct that adversely reflects on the lawyer's fitness as a lawyer. That's also very, very broad. So things that I've seen as examples, because, in order to pass we passed the bar exam, right? Because it's not really a official bar association that really governs us, but we passed the bar exam is what it's called. And in my state, in most states, we have to do a character and fitness assessment after we pass the test. So just passing the test is not enough. So character and fitness involves knowing the rules of professional responsibility, right? And so I've seen some examples in those different cases that we've had to study on conduct that adversely reflects on the lawyer's fitness as a lawyer. Unfortunately, people that have had really severe mental illness, that, maybe they've had outbursts in court, outbursts with clients and things like that. That's the type of conduct they've talked about. They've also talked about where people have addictions issues. They also have talked about where basically sometimes lawyers will just go rogue and they're just doing some criminal stuff. Like they're just acting like a criminal. Basically, you're hiding evidence, you're hiding drugs, you're laundering money. These are very rare cases, but lawyers get caught up in RICO and stuff like that. All of that type of behavior can adversely reflect on the lawyer's fitness as a lawyer. Another one is if people show like an extreme bias, like extreme racial bias, extreme religious bias against a certain type of person, then, you know, maybe you can't be fair in your dealings with people, and that may adversely reflect on your fitness as a lawyer. So under the rules of professional conduct, the prohibition against false statements is broad. Like I said, it's broad, includes misleading statements as well as affirmatively false statements. So misleading is kind of like lies of omission, leaving something out so that it seems one way when it's another, or letting someone believe something that's not true. You know, you have the right to correct that misapprehension. All of those can be misrepresentation. So that's a very low bar. Okay, so let's get right to the thing. So Mr. Giuliani has actually responded to their request, which is good, because a lot of times, like I said, people will not respond. And when you don't respond, the only evidence against you is the person making the complaint on you, or persons making the complaint, and then you're screwed, right? So he's responded. So that's good. So let's see. This is really important. Let's see what Giuliani was saying. So Giuliani respondent is Giuliani. So every time it says respondent, I'm going to say Giuliani so it's clear. Giuliani raises an overarching argument that the AGC's investigation into his conduct violates his First Amendment right to free speech. No. That's a bad response. I'll get into that. He does not attack the constitutionality of the particular disciplinary rules. He seemingly claims that they are unconstitutional as applied to him. We reject respondent's argument. This disciplinary proceeding concerns the professional restrictions imposed on respondent as an attorney to not knowingly misrepresent facts and make false statements in connections with his representation of the client. It is long recognized that speech by an attorney is subject to greater regulation than speech by others. Because this is not your freedom of speech to like live or anything like that. It is to be within a select club of a few people that are allowed to be attorneys and receive all the benefits of the prestige of that profession. And so you don't have as many constitutional protections in your speech that you conduct as an attorney. Now, it's different in the speech that you do in your personal life, but the speech that you conduct before courts, before the public in your representation as an attorney, that is curtailed. And that's a Supreme Court case called Gentile v. State Bar of Nevada, 501 U.S. 1030. So when you see this U.S. designation right here in the citation, that's how you know it's a Supreme Court case. So the Supreme Court has found that lawyer speech before judges and the public as an attorney does not have the same constitutional First Amendment right protections. And another problem with that argument is that basically you are, what's the word I'm looking for? Disregarding or giving up or forfeiting. You're forfeiting the argument that you did not make misrepresentations. Instead, you're saying that I made the misrepresentations, but I'm entitled to make the misrepresentations. And that is not a good argument. You don't want to be you don't want that to be your first argument. I would never even want to put that in there. You're saying that procedurally, you're allowed to say what you said, even though they're lies. You're allowed to say it because you have a First Amendment right of free speech, right? And that is not at all a good place to be in. You're basically admitting that you lied to the tribunal. And that's why they're saying it's uncontroverted. He's not saying he didn't do it. He's saying he's justified or entitled to do it. And you're not going to start from a good place with that. And that's probably one of the reasons they suspended him already. And then we have O'Harlick v. Ohio State Bar Association, another U.S. Supreme Court case that also holds, unlike laypersons, an attorney is a professional trained in the art of persuasion, right? So it's almost like, you know, how someone can be so trained in martial arts that their body becomes designated like a deadly weapon. It's like that. Our speech is a deadly weapon. So we are regulated in when and how we can use it. They are perceived by the public to be in a position of knowledge and therefore a crucial source of information and opinion. People are going to believe us more because we're attorneys. There are people that believed Rudy Giuliani and the things that he said. And even in this filing, he's not saying he didn't do it. He's just saying he was entitled to tell these lies. This weighty responsibility is reflected in the ultimate purpose of disciplinary proceedings, is to protect the public in its reliance upon the integrity and responsibility of the legal profession. This is a local case, a New York case. While there are limits on the extent of which a lawyer's right to free speech may be circumscribed, these limits are not implicated by the circumstances of the knowing misconduct that this court relies upon in granting interim suspension in this case. So basically what they say is that there's limits on curtailing a lawyer's right to free speech, but those limits do not encompass basically someone knowingly lying to the court, because that's strictly forbidden. Okay, now remember I said earlier that one of the defenses that Giuliani could raise is, look, I didn't know that what I was saying was false. I believed, that these allegations that I made were the truth. I believed it at the time that I said it to the court, at the time that I said it to the public, and at the time that I said it to other third parties. And like I said, it's going to be really, really difficult because attorneys have a duty. We have a duty to investigate, a duty of due diligence before we present anything to the court. We can be misled. It does happen. We're human beings, right? And if we have a good justification for why we were misled, I don't know, like someone like straight up lied to my face. They forged evidence and I had no idea that this was false. I wasn't there when it was forged. I had no idea. But it's not okay to just close your eyes, see no evil, hear no evil, speak no evil. You absolutely have to make a factual showing that you tried to discover the truth of the information that you proffered to the court. You have to be very, very careful with that. Okay, so we agree that the rules of professional conduct only prescribe false and misleading statements that are knowingly made, right? In New York, there are no cases which directly hold that a violation of the rule must be knowing, although there is authority that implies it. In a federal case applying New York rules, the court found that there was a violation of the rule where false statements were made by the offending attorney were not inadvertent, but were knowing. So they're saying there's a knowing element, even though it's not spelled out in the court. So they're going so much into the background here. You guys don't need to see that. So we therefore hold that in order to find a violation of this rule, it's required to satisfy a knowing standard, right? Whenever the AGC has sustained its burden of proving that respondent Giuliani made knowing false and misleading factual statements to support his claim that the presidential election was stolen from his client. So these are the claims, guys. Respondent must then demonstrate, so now it's Giuliani's turn, to demonstrate that there is some legitimate dispute about whether the statement is false or whether the statement was made by him without knowledge that it was false. So that's his best defense. Conclusory or vague arguments will not create a controverted issue as to whether there has been misconduct. So you can't just say, I didn't know. You have to have specific facts to create a legitimate dispute as to whether or not either what you said was actually true, like actually what I said was true. There was widespread voter fraud. There were dead people voting in this one state that I made that statement in. There were people throwing out ballots. All of that is true, right? Or that I had good reason to believe that it was true at the time that I made the statements, okay? So once the AGC has established its prima facie is on its face case, respondents' references to affidavits, So this is what the prima facie on its face case is for the Attorney Grievance Committee, okay? So this is what respondent Giuliani did. Respondent Giuliani's references to affidavits he has not provided. So he has had the chance to respond to the commission and their inquiries to him. And they've probably done a lot of letter writing back and forth. Based on my knowledge of these matters, of attorney grievance matters, you do a lot of letter writing back and forth with them. They write to you, you write back to them, and they always ask you to provide proof of the things that you're claiming. So did you not know about this issue? Show me how you didn't know. Show me what caused you to get the misapprehension that you previously had, okay? So now when he was going back and forth with the AGC, that would have been a perfect time for him to provide those affidavits that he talked about in court and to the public. But he did not provide them. or sources of information he has not disclosed, or other nebulous, unspecified information. Nebulous, ephemeral, unknown, right? Murky, unspecified information. So he's made unspecified claims with no concrete evidence to back up the things that he's saying. And under this framework, it starts out with them making an inquiry. And as the attorney who has the duty of professional responsibility, we have the burden of producing the evidence that would actually defend us. It's a little bit different than a criminal case. We have the burden of showing, no, I didn't do this thing, and here's why, right? So let's look at the footnote. In opposition to this motion, respondent refers to affidavits he has not provided. He also relies on a confidential informant. We do not understand, nor does respondent explain why a private attorney seemingly unconnected to law enforcement, he would have access to confidential informants that we cannot also have access to. At yet another point, respondent claims he relied on a Trump attorney who chooses not to be identified. Respondent also refers to hundreds of witnesses, experts, and investigative reports, none of which have been provided or identified, and an Excel spreadsheet, also not provided, purportedly listing the names of thousands of deceased voters who allegedly cast ballots in Michigan. I want to know if you guys are understanding what I'm talking about so far. This footnote is, even though it's in a footnote, is amazingly significant. The reason it's in a footnote is because there are the responses from Giuliani, the letters back and forth. That's all a part of the record. So whatever judge is going to look at this later on down the line when there's actually a hearing on this, they're going to get to see all of that. They don't need to rehash it, but they put it in this footnote. This footnote gives us an amazing insight into what has been going on in this hearing so far. Let me come back to you guys, okay? Hey, guys. Oops. Okay, stop screen. Okay. I'm back. Okay, so Creed says he's got it all. Thank you. Miss Mecca, okay, says, as quick as he was suspended, once all conclusions have come into place, outcomes that is, things are not in his favor. He can't practice law at all. Yeah, it's not in his favor at all. It's not looking very good at this particular moment. There's no attorney in this country that wants to be in Rudy Giuliani's position at this moment. And I don't care what side of the political spectrum that you're on, you do not want to be in Mr. Giuliani's position. There's no spinning this as a positive or a neutral situation. This is all bad. I have a $5 super chat from Jess Green. Thank you very much. I wish Chris Farley was still with us, as do I, just in general, because to me, he was a part of the golden age of SNL. To reenact Andrew Giuliani's reaction to Daddy getting suspended on the next SNL. Oh, should we react to that? Because I saw that we've got 10 minutes before Chauvin's sentencing happens. And I saw that. So I'm not sure if we should react to that, but we should at some point. It was real fun anyway. Okay. John O'Brien with the $2 super chat. Thank you, John. So how does Ben Crump still have a license? Either no one has complained against Ben Crump for anything, basically, for violating the rules of professional responsibility. I don't know what the allegation would be, but whatever it would be. Either no one has filed a complaint against him in the states or states in which he's licensed to practice law, or they have filed complaints and the complaints have not been sustained. So that's how he's still licensed to practice law, John. Hey, Tiffany, thank you for the $5 super chat. Tiffany McGill, I'm a World Trade Center survivor. Well, I'm glad that you're a survivor. I was in New York at the time, but I was Queens resident. I was in high school and we could see the towers from our classroom window, one of the classroom windows. I didn't, thank God, see the plane get hit, but as I'm going over to the next classroom, I look out the window and we just saw all the smoke coming up, and then none of the phones were working, and then it was a bad smell in the air for days and days and days. It was terrifying. And I believe one of my classmates' mother was down there, so it was a terrible event. Rudy was a terrible public servant as far back as I can remember. Not a Shanderford fan, but karma is a thing. That's how you feel, girl. That's how you feel. Let's feel all the feels, because this was a very significant thing that's happening. Eva Roberts with a $5 super chat. Hey, Eva, good to see you. Can't say he isn't telling the truth, because I can see him thinking that way. Now, why does he think that way? No clue. Yeah. Yeah. Okay. I'm just making sure I'm not I want to get to the general chat, guys. Okay. I see one. Julie Holden sent me a $10 super chat. Thank you, Julie. Is some of this internal to New York Law Society? Like his fellow jurors there are so appalled by his behavior that they entered these complaints. His reputation must be in tatters, deservedly so. I mean, I am sure that other attorneys have complained on him, but usually these grievance committees have a duty to respond to all of the complaints, whether that be, thank you for your complaint, we will not be following up on it because what you alleged does not violate our rules of professional responsibility, but you're more than happy to supplement. We are more than happy to accept a supplementation of different information if you have it, or some supporting information or documentation. We'll take that. But what you told us right now is not enough. And they could just dismiss it outright, but they have to at least read it. In other states, for each and every complaint, the attorney has to respond for each and every complaint. Or if it's massive like this, they might lump them all together and say, respond to this allegation that's being made by different people. I'm telling you, it really doesn't matter that it's so public. The behavior itself is strictly disallowed. You know, that's why, you know, maybe because that's why at the time of the election, this is something I was harping on. I was like, I hope he knows what he's doing, because you can't just say that. You can't just say that. And people were like, oh, you can do whatever you want. Lawyers lie all the time. What's the big deal? I'm like, guys, no, like everyday attorneys get disbarred on the daily because of that type of behavior. You really can't say that type of stuff unless you have evidence to back it up or a good faith belief in it. But you can't bring your political posturing into court. You have to know that it comes from some type of facts. And I'm sorry I didn't put your comment up on the screen, but it like timed out and I couldn't see it. Runway with a 10-pound super chat. Thank you, Runway. Is it likely that colleagues and allies will distance themselves from Rudy now? I think it's unlikely because of who his colleagues and his allies are. They've already, that, you know, group of people, and I'm talking about the political group of people, not the supporters so much, but like the actual former president, his attorneys, his associates, all of those people that were like team Trump, right? Team political Trump. They've all built up this great, basically narrative where no matter what happens, they win. If he is not disbarred, it's because he did nothing wrong and there was widespread voter fraud. If he's not suspended, it's because he did nothing wrong. There was no widespread voter fraud. But if he gets punished in any way, it only solidifies their belief that they're being targeted because of their beliefs, and that there's a deep state and that there's corruption, and that the state bar of New York is, or the attorney grievance committee of the state of New York is inherently corrupt and a part of, you know, the deep state, or a part of whatever other widespread conspiracy is going on. Yeah. So I don't think it, you know, the people that don't like Trump and co are not going to like Trump and co. The people that like them, I really don't think that there's anything that would peel away their support or the cronies who like go along for the whole thing, because there's some type of financial benefit. You know, Rudy Giuliani being suspended right now and then potentially disbarred later, potentially means nothing to his actual financial prospects. He'll still have money. He'll still be doing well. He'll still get paid for appearances. If he's put away any of the money he's made up until now, he's likely wealthy than the majority of people in this country, wealthier than a majority of people in this country. So they'll be fine. He'll be fine. And he doesn't actually need to practice law to do well. I wouldn't be surprised if, mark my words on this, I wouldn't be surprised if he just retired from the practice of law, or you can deactivate yourself, right? You can call in, if say I was sick and I'm going to be sick for a long period of time, I'm not going to be representing any clients. I don't want to pay dues in the meantime. I can just deactivate myself. Or sometimes when lawyers become presidents, they're never going to practice law again. More than likely, they're never going to step back into a courtroom. So I know Bill and Hillary Clinton, they're both attorneys, and they both resigned from the practice of law while either he was governor or he was president, one or the other. But they voluntarily resigned from the practice of law. Completely normal for people that are entering into the political sphere and people that are retiring to resign from the practice of law. So I could foresee him doing that before he's disbarred or holding out. But either way, he'll be fine. He'll be fine. Thank you for that, Runway. Okay, I'm just trying to get caught up. I have a £5 super chat from Zara. Thank you. Could his hearing be televised? He's an embarrassment to America. Love you in the channel. Watching from Scotland. Hello, Scotland. No, I don't think his hearing would be televised unless it made it all the way to the appellate courts, like the higher appellate courts in New York. I believe that their hearings are televised, but at the trial level, unlikely to be televised. Although, if someone's interested, there is a right to it's a trial, it's a public hearing. Maybe some media source will ask to be there, but I doubt it. I doubt that they will. But it would be interesting to see if they do. I just don't know. Azur with the $5 super chat. Thank you, Azur. To be honest, I don't think he even cares about practicing law anymore. He's 77 now and a celebrity millionaire. So I agree with you. I think that's right. And I think that that's probably, what's the point in saying, I lied. I'm sorry. I apologize. Please don't take my license away. Just keep up with the same, lies. Because this is something I wanted to explain to you guys why that footnote was so significant. That's really concerning that this is your last ditch effort to save your license to practice law. Rudy Giuliani has been an attorney since 1965, 1966, longer than many people have been alive. He has been a practicing attorney. Okay. And that has been his lifelong pursuit, his lifelong passion, his lifelong profession. Okay. And your last ditch effort to save this thing that you went to 3 years of law school for, you became the highest prosecutor in the state of New York, right? In the city of New York. You worked for the federal government. You were the mayor of New York. You ran for president twice. You were seen as America's mayor. And all of that came back to your practice of law, to you being this tough as nails, tough on crime prosecutor, right? And instead of you trying to save your legacy and save your license to practice law, you say there are affidavits and don't present any affidavits. You can't do that. There's an Excel spreadsheet of people who voted dead and don't provide the Excel spreadsheet. There are confidential informants. Sir, you're no longer the top cop. You're no longer a prosecutor. So you're not entitled to confidential informants. There's no such thing as a confidential informant for a private citizen. There's no such thing as a confidential informant even for a political person, a political body, a politician, a politician's office. You cannot have confidential informants. In the law, we recognize confidential informants for law enforcement and media sources. So I have a source, a confidential source that I'm going to keep off the record, right? And under the First Amendment, you have the right to keep that confidential source. But you are compelled by this body to provide some type of information to back up the things that you're saying. And it's your burden at this point to show that the allegations that you made were true. And you have evidence that the allegations you made were true, but you're not providing it. But now is the time. Okay, so the entire time before the election, this is not, you guys know I am a political person, but this is not to get political. This is to make a point about court procedure. Okay, so up until the point that the election occurred, he kept telling the public it's coming any day now. The evidence is coming to show the widespread voter fraud. And then afterwards, when the court hearings were going on, the evidence is coming. We're going to have our day in court. Widespread voter fraud. The court hearings conclude, they say that there is no evidence of it, but he says there is. You wait until the inauguration. The evidence is going to come out. Donald Trump is going to be president. This fueled January 6th. This is what fueled January 6th, is that the evidence is coming. The evidence is coming. The evidence never comes. Okay, fine. But now you're in a court of law. You're not in a press conference. You're not on an online forum. You're not on Fox News. You have to give this court, if you want to maintain your license, you have no choice but to give them this evidence that you've been sitting on since last year, since 2020, since voting began. And the failure to do so shows that the evidence does not exist. Because if there's one thing, even though he may not care about the practice of law, it's still about self-preservation, because there's still pending criminal charges, right? And the filings here are statements that he's made under the penalties of perjury, because as a lawyer or anyone filing anything with the court, they have to be true to the best of your knowledge, right? Anything you file with the court has to be true, and they're already prosecuting him in the state of New York. All of this stuff is going to be used against him. What better way to show that you're innocent in the upcoming criminal proceedings than in this proceeding, this court proceeding that has to do with your license to practice law, to provide the evidence to back up the things that you're saying. And the failure to do so means that they don't exist. Okay. Give me 1 second, guys. Hey, babe, I'm on live right now.
Oh, you're live? Okay.
Yeah. You want to say hi to the people?
Hey, everybody. How's it going?
Brandon says, hey, how's it going? Okay. Can you text me what you need? Are you good?
No, I'm good. I was just, saying hi.
Okay. Talk to you later. Love you.
Talk to you later. Love you.
Bye. Okay. Okay. Oops. See, this is what they do. Zara with a £2 super chat. Thank you, Zara. What a sad fall from grace. Wow. It is sad. Okay, Tom Royal said they had a missed super chat. I'm going to go back and look. I might not be able to put these on the screen. Chauvin Court is live. Okay, let me get through the super chats that I've missed, and then let's go to the screen. Okay, so, all right. So I'm going to say them, and then I'm going to do like this. Okay, good. Okay. Sorry, it's a little bit delayed. Okay, so I got Zara's. Could this be hearing be televised? I don't think he even cares about practicing law. Got that one. Is it likely that, okay, Tom Royal. Thank you, Tom Royal, for the $5 super chat. Everybody thank Tom. Can you please react to some of Danganronpa cases? It's a video game and it's different than your normal content, but the cases are exciting. I've never heard of this. What is this? Let's make a note. Danganronpa. I can definitely look at it. Thank you. Thank you, Tom Royal. I've never heard of that, so I'm gonna learn something. Oh, trans girl, it's cool. Julie Holden with the $10 super chat. Thank you. It's okay if you guys have to go to Chauvin. I'm about to go to Chauvin with you guys live. Is some of this internal to New York Law Society? We talked about that. Jess Green, I wish Chris Farley was here. We got that. John O'Brien, we got him. Tiffany McGill, we got her. We got Eva Roberts. Thank you. Yin Wolf. Hi, Yin Wolf with the £5 super chat. Hi again. You've spoken on who keeps lawyers in line. Who keeps judges in line? And are police as hesitant to go after them as they are in TV shows? Police are hesitant to go after judges if they do something wrong, understandably so. But I've seen them do it. And as far as who keeps judges in line, in Maryland, it's the Commission on Judicial Disabilities. Every state has an ethics board for judges. It just has a different name, but there's a governing body for them. And although they have absolute immunity, they cannot be civilly sued for anything that they've done in the practice of as being a judge on the bench. They can't be sued for that. They're immune from prosecution and lawsuits. They can be investigated for ethical violations and removed from the bench or disciplined in some other way for, those types of violations. Christopher D with the $4.99 super chat says, thank you for your latest SovSit video. I live for them. Thank you, Christopher D. I live for your support. Thank you. I got a Canadian $5 from Point Curation. Thank you. I am not a SovSit, but there are lines no authority should be allowed to cross. World is getting more authoritarian and it must be refused. I like that, Point Curation. Thank you. Michelle Polk said she only wanted to show her appreciation, and I appreciate you. And I saw it and don't think I put it up. That's a $5 super chat. Thank you very much, Michelle Polk. And then I just have a couple more, and then I'm going to head on over to Mr. Chauvin. I've got Jay McClough with a $1 super sticker. Thank you. I don't see a message there, just so you know. And a $5 super chat from Sean Kennedy. Thank you. People like Giuliani despise democratic principles so much, they are willing to sacrifice themselves for fascistic principles. That's really sad. That's really, really sad because ultimately, okay, gotta go to Chauvin. Gotta do it right now. Don't leave. We're gonna look at it together. Okay. We're gonna look at it together. If my computer just stops being a jerk. Is YouTube going to crash because everyone's on here looking at Derek Chauvin? Okay, here we go. Lord. Here we go. Okay. Share screen. Lord have mercy. I'm about to be up in here. We're about to watch this together and I'm about to cry. I don't want to cry. Guys, don't make me cry. I'm going to try to start it from the beginning. Okay. Here we go. Hold on. If you guys haven't
took their loved one from them. For people who are.
If you guys have not seen this yet, I'm starting it from the beginning of people talking. And I'm going to be looking at your comments on my phone. So is it cool that we watch this together? I hope that we can. I've been trying to stay super professional about all of this. So we're only a few minutes behind, but let's go.
Are speaking to come up to the lectern and use the microphones, and please to remove your mask so that we can hear you clearly, and also to maintain the distances that we have set out in the courtroom. With that, we'll proceed first with the state. Mr. Blackwell, you may proceed with victim input.
Your Honor, we have 4 victim impact statements. We will start with the 7-year-old daughter of George Floyd, Gianna Floyd, who will present hers by video.
What do you miss most about your daddy?
Well, I ask about him all the time. And that's kind of it.
Yeah. Well, when you ask about him, what are you asking about?
Well, I was asking, how did my dad get hurt?
Do you wish that he was still here with us?
Yeah, but he is.
Through his spirit?
Yes.
Yes. And when you see your daddy again one day, what do you want to do when you see him?
I want to play with him.
What kind of games do you want to play with him?
I want to play with him, have fun, go on a plane ride, and that's it.
Yeah. Would you?
We used to have dinner meals every single night before we went to bed. My daddy always used to help me brush my teeth.
Oh. Do you miss him helping brush your teeth?
Yes.
How do you hope that the world remembers him?
Well, they helped him because those mean people did something to him.
Yeah. If you could say anything to your daddy right now, what would it be?
It would be, I miss you and I love you.
All right. Thank you, Gianna. I really appreciate you answering questions today.
That was Gianna Floyd. Your Honor, next we'll hear from the nephew of George Floyd, Brandon Williams.
I appreciate that they did that without her being live in the courtroom, with her being separate. That was actually very, because, you can do a written statement. The person doesn't have to be there to give the victim impact statement, but it's not an appropriate thing for a child to watch a sentencing hearing for the murder of her father. So she just asked her some very nice questions about her daddy, but she probably doesn't realize really what it's for. And I just think that was a very good way to handle it. The little girl is George Floyd's daughter.
Brandon Williams, BRANDON WILLIAMS. On Monday, May 25th, 2020, George Perry Floyd Jr. was murdered by Derek Chauvin in a malicious and insidious display of hate and abuse of power. Chauvin killed George. Not only did he kill George, but he also displayed a total lack of consideration for human life as he did so. You saw it, I saw it, and millions of people across the country and the globe witnessed the act of hate. A year and 1 month later, I stand here before you tasked with the duty of expressing how George's death has impacted me personally and the rest of our family. As I racked my brain and thought about what I could say today, I came to this conclusion. It is humanly impossible for me to stand here and convey or articulate the right words that would capture all that we are feeling and what we have felt over this period. So please bear with me.
Oh, you can't be serious. What's going on? Okay.
But not as nearly unimaginable as the defendant's decision to take the life of a human being with no regard for the effect it may have on others. Although Chauvin will be sentenced today and spend time in prison, he will have the luxury of seeing his family again, talking to him, and he will likely get to spend time with them upon his release. These are all luxuries that my young cousin Giuliani were robbed of when Chauvin made the active decision to kill our father. There will be no more birthday parties, no graduations, holiday gatherings, or other family celebrations. The laughter, hugs, guidance, advice, sense of security, and those opportunities to simply say I love you are forever gone. They say time heals all, and while I generally believe that saying, it's challenging to do so given these unfathomable set of circumstances.
Guys, I'm answering your questions in the chat so that you can see what's happening without me interrupting too much.
Before I conclude, I must highlight a few things. George's murder, this trial, and everything in between has been tragic and devastating. Our family is forever broken. And one thing we cannot get back is George Floyd. It is the request of my family that the maximum penalty for the crime for which the defendant was convicted be imposed. On behalf of my family, friends, community, and supporters, I wish to express my sincerest gratitude for allowing this opportunity of expression. Thank you.
Your Honor, just for the record, this wonderful lady standing here is a Hennepin County victim advocate.
Ms. Boswell is well known to the court.
Yes, thank you, Judge.
And so, Your Honor, we'll next hear from the brother of George Floyd, Mr. Terrence Floyd.
And Mr. Floyd, if you could state your full name, spelling each of your names.
Yes. Terrence Floyd. That's Terrence, Floyd, Floyd.
Go ahead.
I'm here representing my brother. I'm from New York. On May 25th, 2020, my brother was murdered, everyone knows, by Derek Chauvin. The facts of this case were proven beyond a reasonable doubt, and 3 guilty verdicts have been rendered. This situation has really affected me and my family. Any family member that has went through this, we are part of a fraternity of families, and it's not one of those, fraternities that you enjoy. I just, over this last year and months, I actually talked to a few people, and I wanted to know from the man himself why. What were you thinking?
Oh my God.
What was going through your head when you had your knee on my brother's neck?
Oh my God.
Why when you knew that he posed no threat anymore, he was handcuffed, why you didn't at least get up? Why you stayed there? A month before my brother was murdered, I was on the phone with him, and we had a long conversation. And as I looked at the video of my niece.
Derek Chauvin looks furious, and he looks more like when he was first charged back when this happened with the head shaved down.
The last conversation me and my brother had was he wanted to have play dates. He wanted to plan play dates with Giuliani and my daughter. And we started setting it up. That can't happen. And I have to, my daughter's still young, but I still have to explain to her, because this is history. This is a case everybody knows about. So she's gonna find out, and I'm gonna have to explain that to her. And I think that's, to me, harder than even just standing here, that I have to talk to my daughter and tell her, about her niece, about her uncle, about the situation. That's basically reliving it all over again, years down the line. I'm here on behalf of my family, on behalf of me and my family, we seek the maximum penalty. We don't want to see no more slaps on the wrist. We've been through that already. In my community, in my culture, we've been through that already. Smacked on the wrist. No. Because if it was us, if the roles was reversed, there wouldn't be no case. It would have been open and shut. We'd have been under the jail for murdering somebody. So we asked for that same penalty for Derek Chauvin. Thank you.
Thank you, sir.
Your Honor, the final victim impact statement for the state will come from George Floyd's brother, Phalonis Floyd.
Oh. If you guys remember, Phalonis testified at the trial itself to give George Floyd what's called a spark of life, where the family or some loved one or relative can speak or testify on behalf of the deceased person to humanize them in the eyes of the jury. That is possible for all murder cases. Oh.
And sir, if you could begin by giving us your full name and spell each of your names, and I have permitted you to use your phone because you have notes on it, is that correct?
Yes, sir.
All right, and you may proceed when you're ready. Giving us your full name first.
Phalonis Floyd, spelled Philonise, last name Floyd, Floyd.
And you may proceed.
One year ago, May 25th, my brother George was murdered by Derek Chauvin and his co-defendants in broad daylight with a knee to his neck for 9 minutes and 29 seconds. I was a trucker, and immediately my life changed forever. I began to speak to the world for George from the United Nations, Africa, Canada, Japan, and so many other countries. Every day, I have begged for justice to be served, reliving the execution of George, while others begged and pleaded for Officer Chauvin to simply just allow George to take a breath. I haven't had a real night's sleep because of the nightmares I constantly have hearing my brother beg and plead for his life over and over again. Even saying, they're going to kill me. Please, officer. Screaming for our mom. I have had to sit through each day of Officer Derek Chauvin's trial and watch the video of George dying for hours over and over again.
That must have been the worst part for the family, is watching that again and again.
For an entire year, I had to relive George being tortured to death every hour of the day, only taking naps and not knowing what a good night's sleep is anymore. I've been lifting my voice tirelessly every day so that George's death will not be in vain.
And just for the posterity of the video, a lot of people in the comments section are saying that Mr. Chauvin is coming across or looking very angry.
Honorable Judge Peter Cahill, I thank you for allowing me to share this today. George's life mattered. So my family and I, most of all, my niece, Gianna. My niece, Gianna, she needs closure. I'm asking that you please find it suitable to give Officer Chauvin the maximum sentence possible, charge that he has been found guilty for. My family and I have been given a life sentence. We will never be able to get George back. Daddy's our daughter's first love. He would never be able to walk Gianna down the aisle at her wedding, attend those magical moments of her life like a daddy-daughter dance, sweet 16 party, seeing her out for prom graduations, and she would never be able to have any personal memories with her father. With a smirk on his face and children present, Officer Chauvin used excessive force
and acted against his training. Chauvin had no regard for human life, George's life. I stand before you today asking you to please help us find closure by giving Chauvin the maximum sentence possible, making sure he does this time consecutively without the possibilities of parole, probation, or getting out early for good behavior. Thank you.
Thank you, sir.
There can't be a consecutive sentence here because Mr. Chauvin will only be sentenced as to one charge, and that's the second-degree murder. Under Minnesota law, all the other charges subsume into the second-degree murder charge.
Mr. Frank.
Thank you, Your Honor. Here today, of course, for sentencing, gives us an opportunity to speak about other matters that I think are involved in sentencing and where we are in the criminal justice system, in the processing of this case. As a member of an elected office, representing the people of the state of Minnesota, as well as the people of the local community, I want to say a couple of things. And first of all, I want to really thank some of the police officers in the Minneapolis Police Department who, under great pressure, great stress, to some extent at peril to their occupations, what they've devoted their life to, stuck to their oath and their commitment as police officers to speak openly and honestly about policing and the training that is given and received by police officers. Those officers didn't hide behind a blue wall. They came forward, they told this court and those jurors what they knew about training and responsibility. And I think they deserve recognition and credit for that. I would also like to thank members of the Bureau of Criminal Apprehension. Those agents get called in, great sacrifice to their personal lives. Whenever things happen, they go. They did that here, and under really extraordinary circumstances, completed a very professional and thorough investigation. Conducting interviews is hard enough, but conducting them in the atmosphere of the city following the murder of George Floyd was even more difficult. And they did so, I think, above and beyond the call of duty. And I want to thank them for doing that on behalf of the whole prosecution staff. I want to thank the family, the loved ones, the friends of George Floyd. They have been through so much more than families involved in murder cases. He's right. It's a fraternity you don't want to be part of. But they've been through so much more because of the pandemic and because of security, safety precautions that we've had to take. They have been through a lot. At a time when they try to grieve, like everybody does for the loss of someone, they are going through so much more. And I want to thank them, all of them, the family. The court saw a testimony from Philonise Floyd, Courtney Ross. These are people who are trying to deal with their loss, but they have to do it in a very public way and under very trying circumstances through no fault of their own. So I thank them. They have all been models of grace and understanding. And it's really remarkable, quite frankly.
Okay, so with most of you guys, most of you, I know one person's in the minority, I'm sorry. We're going to fast forward only because what he's going to be going through is things that we already know. They're going to ask for 30 years. That is the most they're basically allowed to ask for. The maximum is 40 years in prison, but there's a guidelines range, and they have a case in the state of Minnesota that says that basically you can ask for twice, or the court If they find aggravating circumstances, can find twice of the guidelines, but no more. So the top of the guidelines is 15. The judge can find 30, and that's what they're going to ask for. Anything beyond that 30 risks the sentence being overturned on appeal, and for him to be resentenced, even if he isn't found not guilty, he could potentially be resentenced to a lower sentence. So Cahill is unlikely to go over 30, but the maximum is 40. He's also unlikely to go to 30.
Position of abuse or a position of authority and trust by the community.
These are the aggravating circumstances that the judge found. I just fast forwarded it. Thanks, guys.
By individuals of the community. Your Honor found that Mr. Floyd was treated by Mr. Chauvin with particular cruelty. I think tortured is the right word. We know that, we've all seen it. Mr. Floyd did not want to be in the back seat. That's it. That's the rub. It was the need to get him in that back seat no matter what. And we all saw that once he was pulled out of that back seat, he calmed right down, even willingly went down to the ground. I'm going down, he said. And he went down to the ground, not fighting, not punching. And he was placed initially on his side, being ignored. His concerns are being dismissed by somebody who has taken custody but not care. He was kept in that prone position for 9.5 minutes and was suffocated. There's no other way to say it. That's particularly cruel. That is more cruel than a typical second-degree unintentional murder. Significantly more. This is not a momentary gunshot, punch to the face. This is 9.5 minutes of cruelty to a man who was helpless and just begging for his life. This court found that there were children present. Standing on.
The aggravating factors are what the court needs to determine in order to go over the sentencing guidelines. And here, the top of the sentencing guidelines is 15 years. And the prosecution is laying out why they think the judge should go over them. The judge has already found these aggravating circumstances to be in place. Chauvin's position of authority, Floyd's particular vulnerability, and the presence of children is what they've covered so far.
Only a few feet from these officers. These children who were ages 17 and one child age 9. Why is that an aggravating factor? Well, I think everybody can figure that out. Right? It's particularly bad to commit a crime in front of children. We've heard a lot of academia about the development of the young brain and how long it can take. And here you got a couple of teenage girls and a 9-year-old girl. How are they going to process this? Standing feet from a man being suffocated by police officers. Such a stark sight that one of the children even says, we got to call the police on the police. How do you process that as a 9-year-old?
Ooh, he's getting upset.
The children were not only present watching a man die. We've all seen, if you haven't, you really need to look at George Floyd's face as he's dying, he's suffering. The children have to watch this. But not only that, police officers, and there are people around them wanting to help. And at one point, and sure, they got upset. And at one point, Mr. Chauvin points his mace, grabs his mace to keep him back. How does a child look at that? There's another officer screaming at them to get back. A typical second-degree unintentional murder doesn't involve children standing feet away, watching a 9.5-minute suffocation of a man begging for his life.
I think the prosecutor's getting a little choked up.
This court also made a finding that the defendant committed the offense with the involvement of 3 or more other persons. Lane and King were involved directly in the restraint.
So real quick, Tara asked, how could they prove that Chauvin set out to kill him? I don't see it. So hey girl, hey Tara. If you followed along with us in the live streams previously when this case was active in trial, I'll just explain this to people real quick if you're new to the channel. So basically, they did not have to show an intent to kill. 2nd degree unintentional murder is what he's charged with. So no intent to kill. It is felony murder. He had to simply intend to commit an assault. The assault was putting the knee to the neck. He did not have to know that that would result in Floyd's death. However, the knee to the neck did lead to the death, as what was shown by the medical examiner, the pulmonologist, the cardiologist, everyone who testified on the state's behalf. They didn't really have any good evidence from the defense to rebut that that was the cause of death. They tried to bring in other things, but it didn't seem to overwhelm that it was the cause of death. And it didn't have to be the sole cause of death. It only had to be one of the contributing factors or the major contributing factor to Mr. Floyd's death. Were it not for the knee of the neck, would Mr. Floyd have died? And the answer by the jury was no, he would not have died were it not for the knee to the neck, no matter what pre-existing conditions he had or what else was going on that day. And Mr. Chauvin did not have to intend to kill Mr. Floyd. Nothing that Mr. Chauvin was convicted of had an element of intent to kill in it. And that's why he was convicted. They did not charge him with 1st degree murder. It's also why he's not facing life in prison. I hope that makes sense. Thanks for the question.
And that's how kept the bystanders at bay. I've already talked a little bit about Lane and King's role in holding Mr. Floyd down. They recognized that he was pulseless, and Mr. Floyd was pulseless at one point, and yet really made no effort to take care of the person in their custody. Officer Tao watched most of the suffocation and then only went over to keep people from giving help. One person who is identified as a medical trained firefighter for the city of Minneapolis, and that was dismissed. Like, are we going to believe her? So they kept trained medical people from providing help. These were all uniformed peace officers, adding to that abuse of trust and authority. I know the defense has asked the court for probation. I'm not going to spend a lot of time arguing that. It's so outside of the realm of, I think, real possibility. This is a murder. I understand some of the arguments made on behalf of Mr. Chauvin. I can't understand what his family members and friends are going through. I can't. But it's certainly not enough for a departure to probation for a 2nd degree murder. We believe, Your Honor, that these 4 aggravating factors, the court and the findings that the court has made, certainly justify an upward departure, because there are 4 of them, not standing alone, but in a sense, not overlapping, but coming together to show this is not the typical 2nd degree murder. This is egregious. And this justifies a double upward departure. From the top of the box, which is 180 months, we're asking the court to do a double departure, recognizing all 4 factors, to 360 months. As I mentioned before, Your Honor, this is sentencing. This is the time for victims, right? This is the time for the loved ones of the victim and the community to have a say. Again, I commend this family. I commend all of the loved ones, the friends.
He's getting emotional.
People that have been involved in this case for tolerating and
Do you guys think that you could have this case on either side, prosecution or defense, and not get emotional? I don't know. Myself, I've rarely gotten emotional in court about the case itself. And so I just wonder if I would be able to, no matter what side I'm on, they all fought so hard, if I'd be able to keep it together. Let me know what you guys think.
Being gracious.
I'm going to move
None of us,
forward.
of course, can bring George Floyd back. That's very true. But this is the time for our criminal justice system to say, we hear you.
It's a good point.
This is the time for their criminal justice system to say, we recognize that this harm you're going through is real. And while we can't feel what you're feeling, we know we can do what your criminal justice system should do and recognize the severity of this crime and reflect that in the sentence to be given. It's time for this criminal justice system to say, we recognize this is more serious than a typical second-degree unintentional murder. For reasons the court...
Did you guys catch Cahill's head nod right there? Look at the screen. I'm going to rewind it just a little bit. Look at this.
That this harm you're going through is real.
Watch Cahill. Don't look at the attorney. Look at Cahill.
We can do what your criminal justice system should do and recognize the severity of this crime and reflect that in the sentence to be given. It's time for this criminal justice system to say, we recognize this is more serious than a typical second-degree unintentional murder. The 4 reasons the court found reflect that and give this court more than an adequate basis to do that. Your Honor, we ask the court to impose a sentence of 360 months committed to the Commissioner of Corrections. As you know, Your Honor, there are no fines in murder cases. And we would ask the court just to reserve the issue of restitution.
And we're talking in the chat, guys. So if you're watching the replay, go ahead and check the live chat. We're going back and forth because I don't want to interrupt this too much. But I'm just saying this right here for anyone that's going to be in the replay. Listen, you got to look at your judge's body language. Cahill is good because he's been defense, he's been prosecution, and he's been a judge for a really, really long time, right? So he's not he doesn't really signal himself a lot. So even little motions from him are very significant to me. That head nod, when they were particularly asking for the 30 years, is significant. I still don't think he's going to give 30 years, but he's definitely not giving time served. I think Mr. Chauvin is going to get a significant period of time in prison.
Of restitution. We can clarify that with the family and present that to the court for 30 days. Thank you, Your Honor.
Anything further from the state?
No, Your Honor.
All right. Mr. Nelson. I'm sorry. Mr. Blackwell?
Sorry, I just thank you, Your Honor. Your Honor, at this time, the defendant's mother, Carolyn Palenti, would like to address the court.
Awesome. We haven't heard from any of his family members since this whole trial started. He didn't have a single character witness or anything like that. This is going to be great. Okay.
If you could state your full name, spelling each of your names, and proceed when you're ready.
Carolyn, Carolyn, Palenti, Pawlenty. I am the mother of Derek Chauvin. I am here to speak on behalf of my entire family.
Sorry. One more thing. I'm so sorry, guys. I'll try to make this quick. This is good because Mr. Chauvin cannot, I don't think he can give a statement. Everyone's been asking me that. I don't think he can. His case is going up for appeal. Things that he says can be used against him on the appeal. They can be used against him later. Everything is incriminating, even expressing remorse, right? So his family can speak for him and express remorse on his behalf, as well as ask for leniency for him. So that's why mom is really, really important. So let's tune in here. Sorry.
On November 25th, 2020, not only did Derek's life change forever, but so did mine and my family's. Derek devoted 19 years of his life to the Minneapolis Police Department. It has been difficult for me to hear and read what the media, public, and prosecution team believe Derek to be an aggressive, heartless, and uncaring person. I can tell you that is far from the truth. My son's identity has also been reduced to that as a racist. I want this court to know that none of these things are true and that my son is a good man. Derek always dedicated his life and time to the police department. Even on his days off, he would call in to see if they needed help. Derek is a quiet, thoughtful, honorable, and selfless man. He has a big heart, and he always has put others before his own. The public will never know the loving and caring man he is, but his family does. Even though I have not spoken publicly, I have always supported him 100% and always will. Derek has played over and over in his head the events of that day.
This part is really important.
I've seen the toll it has taken on him. I believe a lengthy sentence will not serve Derek well. When you sentence my son, you will also be sentencing me. I will not be able to see Derek, talk to him on the phone, or give him our special hug. Plus the fact that when he is released, his father and I most likely will not be here. Derek, my happiest moment is when I gave birth to you. And my second is when I was honored to pin your police badge on you. I remember you whispering to me, "Don't stick me with it." Derek, I want you to know I have always believed in your innocence, and I will never waver from that. I have read numerous letters from people around the world that also believe in your innocence. No matter where you go, where you are, I will.
So she hasn't expressed any remorse on his behalf. This is a defiant, he's innocent. He's been made out to them by the media to be a bad guy and a racist, but he is not type of statement. But what I don't hold against her is that she loves her son, right? It's going to be hard. It's really hard to find a criminal defendant whose mom doesn't still love him. You know, a person convicted of a heinous crime, even when that happens, it is so rare. It is so rare that it is remarkable, and attorneys will remark on it because we see everything. We see how the sausage is made. You can tell when the family doesn't support them. That he has his family support is not out of the ordinary. It's human nature. It's her child. She wants to defend him. But as far as this serving him in his sentencing, I don't see it because it's defiant. And I get it. I get it because it's his mom. And, you know, so people's mothers will defend them to the end of the earth. But they needed a certain function to be served. And that function, I don't think, has been served thus far.
I'll always be there to visit you. I promise you I will stay strong, as we talked about. And I want you to do the same for me. I will do what you told me to do, take care of myself. So I will be here for you when you come home.
Hey guys, I see that you're disagreeing with James Blonde 007. she has the right to her opinion. She's upset because she thinks that his mother is being disrespected in the comment section. I don't think she's being disrespected. I think people are disagreeing with her opinion on her son. I think she's entitled to her opinion on her son. I really, really do. Strategically, I don't think it's great for his sentencing, but that's just my opinion. But please don't time her out. I don't see her being actively disrespectful to anyone or calling names or anything. It's just her opinion. Let her have her opinion. And let's keep the comments respectful. Okay, guys? Thank you.
Remember, there is no stronger bond or love than a mother's love. One final thought I want you to remember. Remember, you are my favorite son. Thank you for your time.
I hope she doesn't have another son.
Mr. Nelson.
Thank you very much, Your Honor. It is my intent that my remarks this afternoon be quite brief. I do not intend to relitigate the facts of this case, nor spend any substantial time looking at the law. The court is very familiar with the facts of this case, and the parties have fully briefed the court relevant to the sentencing factors. And we recognize that in any case, any sentencing that comes before the court is tasked with a difficult job. The court must craft a sentence that serves the interests of justice, a rather nebulous term. The court must take into consideration victim impact, public interest, as well as the circumstances and the history of the defendant. And in this case, more than any other, that likely any of us have ever been involved in, that task is exceedingly more difficult. In my remarks today, I just wish to briefly address each of those three considerations, starting with the public impact. As I believe we are all cognizant of,
We're going to have to do a lot of talking about Mom's mitigation statement on behalf of Mr. Chauvin, because it's causing a serious uproar here. But just know that I guess maybe I'm a little bit jaded because I'm an attorney. I've heard parents come up and defend their children. This is a heinous act, for the most heinous of acts. And it's the effect that it's going to have on the judge himself who's making the sentence, guys, is minimal. This is not the first time he's heard this, okay? That a mother loves her son is not anything that is surprising. It was ineffective, I believe, because she basically excused him and made it seem like the media was out to get him and he did nothing wrong and he's innocent. She didn't express any remorse on his behalf. She didn't even address George Floyd or George Floyd's family and say that he was sorry for she was sorry for their family. That's not good. That would have been a good time for her to do that. But again, they all have their minds towards the appeal. They're still in fight mode. They're not thinking about, yes, still preserve for the appeal, but good God, don't get 30 years, which is what the state is asking for. So that's why I'm at with this. The victim impact statement as well as the mitigating statement have about equal weight in the judge's mind. And the judge should not make his decision until he's heard everything from all sides and given everyone an opportunity to be heard. But it's not the it's not the sole overriding decision. And those types of statements, they're allowed to be emotional. It's okay that they're emotional. There's not a problem with that. Okay, I was just trying to address some of your guys' questions on that because I see that it's like burning up the comment section. Let's go back to it. Thanks, guys.
this case is at the epicenter of a cultural and political divide. We tried to keep a lot of that out of the courtroom during the trial and make this case about the facts. But we recognize...
Take your shoes off, like the video.
As a result of this case. There are a great number of people who will view any sentence you pronounce as overly lenient and insufficient to satisfy justice.
Smart.
But there are an equal number of people who will view any sentence you pronounce as draconian or overbearing.
Smart strategy.
Either way, some percentage of the public will view your sentence as a miscarriage of justice. The intensity of the public interest in this case cannot be understated. I trust that the volume of correspondence that each of us has received from the public at large is indicative of these very sentiments on both sides. As I was informed just yesterday, the Attorney General's office established a web submission to accept community impact statements. Again, in my understanding is in a little over 2 weeks, they received over 1,000 submissions. Again, on both sides. By my very best estimate, since my representation of Mr. Chauvin began last summer, I would estimate that I have received over 5,000 emails, over 1,000 voicemails, and hundreds of handwritten letters. Again, from both sides. And I expect that Your Honor has likewise been inundated with public comment and scrutiny. The impact that this case has had on this community is profound. It goes far beyond what happened on May 25th of last year. It has been at the forefront of our national consciousness, and it has weaved its way into nearly every facet of our lives, from the entertainment that we consume to the presidential politics, from protests to conspiracy theories. In the end, it is my sincere hope that when this proverbial dust settles, the community impact brings forth principled debate and civil public discourse, and ultimately leaves a positive effect on the city of Minneapolis, the state of Minnesota, and the United States. But nevertheless, while this court may consider the community impact, it is for these very same reasons that the court must turn to the foundational legal principles and remember that justice is blind. Law is built on reason and common sense, and it cannot be permitted to be assailed by public opinion. Turning to the second consideration, which is the victim impact, the death of George Floyd. The death of George Floyd was tragic. He is loved by his family members. He is loved by his friends. And his death is justifiably mourned by those whose lives he impacted. He is a son. He is a brother, a father, an uncle, and a friend of many. And as the court heard today, the impact and the loss of his life, simply just, it can't be simplified.
Okay, this is excellent defense strategy in mitigation. So he talks about the factors that the court is to consider in fashioning a sentence. You talk about the impact on the community. You talk about the deterrent effect. You talk about the retributive effect. You talk about the victim and the victim's family. These are all things that the judge is considering in sentencing. And I was criticizing him in the comments because I was like, I haven't heard him mention George Floyd yet. He finally has, and George Floyd's family. You have to address the elephant in the room, that there is a dead person as a result of what the judge found, the jury found, as a result of your client's actions. So you can say, my client maintains his innocence. However, our sincere condolences go out to his family, right? And so this is good. I wish he had gotten to this sooner, but that's a small picayune thing. But this is a good strategy right here. And that's all, that's what it is. It's strategy, and it's good strategy.
And it will take time. Finally, Your Honor, the court must take into consideration, just like it has to take into consideration the aggravating factors, it needs to take into consideration the mitigating factors. And the mitigating factors as set forth by the sentencing guidelines really point to the TROG analysis, essentially, ultimately in this case. We're not going to spend a lot of time, again, arguing for a probationary sentence. That's briefed.
The probationary sentence he's requesting in a murder case is a ludicrous sentence. That's ludicrous. I mean, and again, we're supposed to try to get the best possible things for our client. But even if I was going to ask for probation for my client because that's what he wants, and there's no other way he would take me asking for higher than probation, I would also say, Your Honor, in the alternative, we would ask for a sentence at the bottom of the guidelines or some sentence under the guidelines. You have to give the judge something that's reasonable so that the only thing, they can't be left with your suggestion being so extreme that the state's suggestion is the only one that sounds reasonable. You can't do that. You have to give them something else. A probationary sentence is a ridiculous request.
But that being said, when we look at the TROG factors, who is Derek Chauvin? Derek Chauvin spent 19 years as a Minneapolis police officer. He loved being a police officer. I was contacted during the course of my representation and have had numerous conversations with his fellow police officers that worked with Derek, some retired, some still active. And they told me that he was a solid police officer, that he did his job, that if somebody asked him to do a particular task, he never complained, he did it. One person told me that one of his sergeants told me that if I had asked him to dig a ditch for 8 hours, he would have picked up a shovel and he would have never complained for a second. He would have done his job. He was decorated as a police officer, multiple life-saving awards. He was decorated for valor. He was proud to be a police officer because what he liked to do was help people. And the statistics show, the vast majority of police work is helping people. He was proud to be a Minneapolis police officer. He served his country as the United States in the United States Army. And
Guys, he can't address what Mr. Chauvin actually did in this case, right? He has to talk about his history of service. He has to talk about why he really became a police officer. He has to talk about the good guy that he was up until this point in time, because something that bears mentioning, he can't present a justification for Mr. Chauvin's behavior towards Mr. Floyd. The mom can say, oh, he's not guilty, but there's no question that Mr. Chauvin knelt his knee into Mr. Floyd's neck. That's on video. Whether or not that constitutes second-degree unintentional murder is the question that the defense still wants to raise, right? And so he's not getting into that. All he's saying is that up until this point, he was a good guy, right? He was a good cop. So just pay attention to that.
2 is a son, and a brother, and a father, and a friend. He too, his life, the life he's lived, he's not coming into this as a career criminal with 6 points, 5 points, 4 points. He's coming into this never having violated the law because he lived an honorable life and he attempted to live an honorable life. Derek Chauvin was not even scheduled to work on May 25th, 2020. He volunteered because there was short staffing at the time. I know from numerous conversations that I've had with Derek that his brain is littered with what ifs.
Here we go.
I just did not agree to go in that day. What if things had gone differently? What if I never responded to that call? What if? The truth of the matter is, and the end result is that we are here after a jury verdict, finding him
no spoilers
of these offenses. And the court's consideration should not only be focused on the aggravating factors, but the mitigating factors as well. The Minnesota Sentencing Guidelines Commission was established for a reason. And yes, the court in circumstances like these has discretion to go beyond an aggravated sentence beyond the presumptive sentences established by the sentencing guidelines. But the sentencing guidelines don't differentiate between second-degree murders. Someone robs a liquor store, a police officer is involved in an incident, and a person dies in police custody. The law presumes, the legislature presumes that the sentencing guidelines as established is a sufficient penalty for all of the second-degree murder categories or cases you would see. From 2019 back to 2010, a total of 90 people were sentenced for second-degree murder. Those sentences, those people, there were more than that, the people who had a 0 criminal history score, more than 90 people were sentenced. 67% or 60 of those 90 people received a guideline sentence of 150 months. So 2/3 of all people in this same position received a guideline sentence. 20% received an aggravated sentence, 18 of the 90, and 13% or 12 individuals were granted mitigated departures. So if the legislature and the intent of the sentencing guidelines is to eliminate sentencing disparity, the law should presume that the guideline sentence is what is appropriate in this case. The judge may take into consideration at this point those aggravating factors, but you have to counterbalance them, which is the goal of the law, with the mitigating factors. I know that this has been an incredibly difficult case for the Floyd family to have to endure. The state of Minnesota, likewise, prosecutors in this case have endured quite a bit, as has Mr. Chauvin's family. This is a case that has changed the world to some degree, and I hope it's positive. But it's my hope that the court follows the sentencing guidelines, applies the law in a reasoned manner, and imposes a just sentence.
Thank you, Mr. Chauvin. Would you join Mr. Nelson at the lectern?
Oh. Okay. He's going to advise him on his right to make a mitigating statement, I think. And he wants to make sure that either he's waiving that right or exercising that right knowingly and freely and intelligently. Okay.
Mr. Chauvin, this is your opportunity if you wish to give any input to the court. And so I turn it over to you and your attorney.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time.
He's talking about the fact that he has a pending appeal, and I forgot to mention this, he's also been charged by the feds, and anything he says here will be used against him in the federal case as well for deprivation of rights under color of law. So that charge, which carries, I think, a life sentence, guys, if I remember correctly, it carries a life sentence. He's still pending that. So really, it's not a good strategy for him to make any statements. And he's making it clear that I have pending legal matters, so I'm staying quiet. Let me just go back a little bit. Sorry. So I was busy talking to you guys and running my mouth.
And so I turn it over to you and your attorney.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I do want to give my condolences to the Floyd family.
Perfect.
There's going to be some other information in the future that would be of interest. And I hope things will give you some peace of mind. Thank you.
Is he negotiating a deal with the feds? Is he negotiating a deal with the feds? What's going to be the information in the future that's going to give the Floyd family some peace of mind? Guys, can I go back and look at this one more time? I'm so sorry. I know I'm like getting you guys out of live time. And if you're just now joining the stream, make sure you like the video, but please no spoilers. We're watching this in real time and I'm reacting to it in real time. I don't know if people notice that that's significant what he just said. Hold on. So sorry. Here we go.
Actually, Mr. Chauvin, would you join Mr. Nelson at the lectern? Mr. Chauvin, this is your opportunity if you wish to give any input to the court. And so I turn it over to you and your attorney.
Thank you, Your Honor. At this time, due to some additional legal matters at hand, I'm not able to give a full formal statement at this time. But very briefly, though, I do want to give my condolences to the Floyd family.
Okay. Good.
There's going to be some other information in the future that would be of interest. And I hope things will give you some peace of mind. Thank you.
I think he's working out a deal with the feds. That's my opinion. I think he's I think they're still they're on break right now. I think he's working out a deal with the feds. Mark me, I'll be making these predictions like, like I think I'm Nostradamus or something like that. And I hate making predictions because, you can always be wrong. But I think, why would you address the family and say to the family that something may come in the future that will bring them some peace of mind? Like, I hope they'll have some peace of mind and there's more information coming out in the future. If there was more information coming out in the future that would exonerate you and show that you weren't guilty, then maybe you have a new expert opinion. Then maybe that wouldn't give them peace of mind, right? Maybe that would upset them further if you had some more information to try and attack the conviction. But are you going to try to work out something with the feds where you'll just accept guilt? Because remember, under the previous administration, when William Barr was the attorney general, we talked about this previously, also very, very important to know this in case you don't, Derek Chauvin attempted to work out a plea deal with the federal government where he would plead guilty to second-degree murder in Minneapolis, in Minnesota, in exchange for the feds not prosecuting him. Like, I'll just plead guilty, forego a trial altogether to the top charge of second-degree murder if you decide that you will not prosecute me. And the feds were down with it until it got to William Barr, Trump's attorney general, who said, no, we're not doing that. We're going to prosecute you. Even if Donald Trump had won, William Barr was probably still going to pursue a prosecution against Derek Chauvin. And so I can only imagine that either he's leaving his appellate options open, his trial options open, but in addition, there's potentially a deal that's being worked out to avoid a federal trial. Let me know what you guys think about that. But that's just based on what he said just there. That's a weird thing to say.
And I'll note that I did read your comments in the pre-sentence investigation as well.
Thanks, John.
All right, we are going to take a 15-minute recess so that I can complete the sentencing order based on what I've heard today. And let's reconvene at 2:45.
2:45. Okay, it's 3:44. They should be about to reconvene then. Oh, just on time. I run my mouth just enough.
So, attorney.
Okay.
The family. Also,
I'm going to mute that. I'm going to leave it on live. And you guys are going to shout at me when it comes back. It should be coming back shortly. Come on, boo. Stop freezing on me. It's like, no, I will freeze on you all that I want, you silly goose. Okay, stop screen. Hi, 953 viewers. Amazing. Thank you. My name is Natalie. I'm a criminal defense attorney. In case you don't know, we've been on this stream. At first, we were talking about Rudy Giuliani being suspended from the practice of law in the state of New York, but also anticipating that the Derek Chauvin sentencing was going to start. We live reacted to that. We're a little bit behind on it, but we just caught up and it should be getting going. Right now, I've been trying to keep up with the super chats, and I hope that you guys accept that the super chats I was responding to them in the chat itself so that I wasn't repeatedly interrupting the stream. So I hope that that's okay with you guys, that you don't take offense to that. But I tried to thank all of you individually and also answer your questions in the chat. And so that was an amazing conversation. Thank you guys so much for helping me to move the stream along so that everyone could see what was going on. So right now we are talking about Derek Chauvin's sentencing phase. And I think that there was a bombshell thing that happened there at the end. And I don't know even if like the pundits and things picked up on it, but I think that there was something there that was significant. And they're back. Oh, wow. Okay. That took no time. Okay. Let's share. Washington Post is not back. I'm on Fox and Fox is back. What services will be provided to Mr. Floyd's daughter, that poor baby? I hope something. But, you know, if anything, you know, the family did receive some funds and things like that. And so I would hope that the family would make sure that, you know, the baby receives some type of assistance or help or something like that, because she's definitely going to need it. Fox is not back. Okay, there's Cahill. Oh, no, that's not Cahill. That's just the... What's going on? Why isn't Fox back? They did settle with the city. And yeah, I said that they received funds. And so they have the resources to provide her with therapy. But I think that that does raise an interesting question, which is... Okay, no, they're still just talking about protests and things like that. It's an interesting question. Am I not sharing my screen? Lord have mercy. Hey, OPT, thank you. You've done an exceptional job today. Really good work on the stream. Thank you very much, OPT lawyer. I appreciate you. Thank you for the super chat. Everyone, OPT is a super warrior fighter. Please send him love and hugs. Bumble Homestead with $5 super chat. Thank you. What services will be provided? Okay, so thank you for the super chat. But I think that the family now has the resources to provide her with services, which is good. But in general, I think that what's happening here? Okay. There's a delay, guys. There's a delay between me and you. Sorry. But in general, I think that the victims of the family that are the collateral victims of state-sponsored crime, state-sponsored violence, because he was a police officer, should receive services for free from the state. I've got more super chats coming in, and guys, I'm going to keep reading them so that we can stay on top of things. Guys, have they gotten started yet? Tom Royal with the $5 super chat. Thank you very much, Tom. How likely do you think it would be for him to be convicted in the federal case? What information can you give us about it and how that goes? I think so. It's a different standard in the federal case, as in they have to just prove that he deprived. It's not a murder charge because they don't charge federally for murder. They have to prove that he deprived George Floyd of his rights under the Constitution, and that he was a state actor or appearing to act as a state actor at the time. And that is basically it. And then he would be guilty. So, and I think that carries life. I have to double check that. But I'll do some more information because I've really been doing most of my research towards the state case and not the federal case. But it's a totally different standard. I can keep you guys updated on that as it happens. Hey, Catherine Siverts. $5 super chat. Thank you very much. Run your mouth. Lots of red X's. I'm here for your thoughts and impressions. Love it. Thank you, Catherine. I appreciate that. Hey, Ryan Blackhawk. I like your hat. $5 super chat. Love your analysis. What do you think the sentence will be? 15 to 20 years. So top of the guidelines to maybe 20 years. I don't think he's going to do the double the guidelines thing. I don't think he's going to do that. We still have to remember that, yes, it's heinous. So I think it's going to go over guidelines. So maybe 20, but then you have to counterbalance that with the fact that Chauvin has no criminal record. So I'm thinking 15 to 20 or 20. Oh, there's Cahill. Okay.
Years before himself. And we see that Judge Peter Cahill is taking the seat right now.
Okay.
Let's listen in.
Here we go.
Well, first of all, I wanted to thank everybody.
Thank you, Lynn, for the super chat. I'll be responding in the comments.
Not just the people who were in the courtroom here, but also those who provided written statements, both from the Floyd family and the defendant's family. I've read all the impact statements that were submitted earlier and listened carefully to all the input here today. And it is truly appreciated that you took the time to stay with this case and to provide me with input. I have reviewed the pre-sentence investigation and carefully considered all the facts of the case and the law, but my comments are actually going to be very brief.
Okay.
Because most of it's going to be in writing.
Oh.
I have a 22-page memorandum that is going to be attached to the sentencing order.
Oh, I'm going to read that.
Why am I doing it in writing? To emphasize the fact that determining the appropriate sentence in any case, and in this case,
takes a lot of thought,
is a legal analysis. It's applying the rule of law to the facts of an individual and specific case. And that is why, as opposed to trying to being profound here on the record, I prefer that you read the legal analysis that explains how I determine the sentence in this case.
I'm nervous.
What the case is, or what the sentence is not based on, is emotion or sympathy. But at the same time, I want to acknowledge the deep and tremendous pain that all the families are feeling, especially the Floyd family. You have our sympathies. And I acknowledge and hear the pain that you are feeling. I acknowledge the pain not only of those in this courtroom, but the Floyd family who are outside this courtroom and other members of the community. It has been painful throughout Hennepin County, throughout the state of Minnesota, and even the country. But most importantly, we need to recognize the pain of the Floyd family. I'm not going to attempt to be profound or clever because it's not the appropriate time. I'm not basing my sentence also on public opinion.
That's right. That's
I'm
tough.
not basing it on any attempt to send any messages. A trial court judge, the job of a trial court judge is to apply the law to specific facts and to deal with individual cases. And so, Chauvin, as to count one, based on the verdict of the jury, finding you guilty of unintentional second-degree murder while committing a felony under Minnesota Statute 609.19 subdivision 2, paren 1, it is the judgment of the court that you now stand convicted of that offense. Pursuant to Minnesota Statute section 609.04, counts 2 and 3 will remain unadjudicated as they are lesser offenses of count 1. As sentenced for count 1, the court commits you to the custody of the Commissioner of Corrections for a period of 270 months. That's 270. That is a 10-year addition to the presumptive sentence of 150 months. This is based on your abuse of a position of trust and authority, and also the particular cruelty shown to George Floyd. You're granted credit for 199 days already served. Pay the mandatory surcharge of $78 to be paid from prison wages. You're prohibited from possessing firearms, ammunition.
I think that's, what? What does that mean?
Or explosives for the remainder of your life. Provided DNA
I think it's 22 and a half years.
Register as a predatory offender.
That's 22 and a half years.
And you will get receive a copy of the order and also the attached memorandum explaining the court's analysis. Anything further from the state?
If this needs to be said, we just ask that it be executed forthwith.
Defendant is remanded to the custody of the sheriff to be transported back to the DOC or whichever custody is currently holding him. Anything from the defense? All right. Thank you. We are adjourned.
Wow. Okay, so I will be breaking down Judge Cahill's order once it becomes public, but 22 and a half years is, so you guys asked me what I thought, and I thought that it would be 15 to 20. So it's even more time than what I thought it was going to be, 22 and a half years. So just in the chat, you guys had a lot of questions about something, a particular factor. And that factor was, what are the guidelines, right? And what's the maximum penalty? So we'll start with the maximum penalty. The maximum penalty is 40 years, okay? That's the maximum possible penalty. However, the sentencing guidelines, which is informative upon the court and takes into consideration the special vulnerability of the victim, the surrounding circumstances of the crime, the position of power, authority, or control of the defendant, and how severe or depraved the crime was. Those are the aggravating factors, right? It takes into account aggravating factors. There are more, but those are the ones that pertain to this case. So special vulnerability, George Floyd was not well. That's the defense pretty much established that. He had pre-existing conditions, heart conditions, addictions issues, and was clearly under the influence of something to the officer at the time that he was detained. And then Mr. Chauvin kneeled to his neck. And he was also vulnerable because he was a suspect under the control of the police. You can't really fight back and fight for your life against the police. They have special control. So then the special authority of the defendant was the fact that he was a law enforcement officer, has more authority than the regular everyday person. Then the next was those surrounding circumstances, such as a vulnerable audience, or it was committed in front of a vulnerable person. Here, children. There were 2 children, underage people available. I think available present, like a 9-year-old and an early teen or something at the time that this happened, right? 2 of them were children. And then there was also the depravity of the act. It was especially depraved, according to the judge, in his memorandum in which he found the aggravating circumstances. And he's already committed that to a memorandum, but it was especially heinous to the judge that that Mr. Chauvin knelt into Mr. Floyd's neck for as long as he did, while people were crying for him to stop, right? And he abused his position of authority. So those are the aggravating factors. And then here are the mitigating circumstances. Mitigating circumstances would be things like, you have no criminal history. You've never violated probation before. You've never failed to appear. You've maintained work. Another one would be the special vulnerability of the defendant. Say the defendant, for some reason, has mental disability or learning disabilities, or they had a very, very bad childhood that gave them almost no chance at life, right? Or they stole something, but they were starving, and that's why they stole. Those are things, they're special defendant vulnerability, right? So the judge takes all of those factors together, but if he finds the finds the aggravating factors, the judge has the ability to go over the sentencing guidelines. So here's what the sentencing guidelines were. They were 10 years and 8 months to 15 years, okay? So the judge should stay within those guidelines, but because he found by his memorandum aggravating factors, and actually let me take you guys to the aggravating factors that he found so that you can kind of understand why we are where we are here. Because the judge found aggravating factors, he went over the guidelines. But uniquely in the state of Minnesota, different from the state of Maryland, in which I practice, right? I practice in the state of Maryland. The courts, there's a court case that literally diminishes a judge's ability to go hog wild over the sentencing guidelines, even if they find the aggravating factors. Okay. So it doesn't say that he wholesale can't do it, but it subjects him to more scrutiny than another judge who hadn't gone so far over the guidelines. So imagine going from 15 years to saying, I find aggravating factors, so I'm going to give you 40 years in prison. The courts in Minnesota, the appellate courts, they don't want that. Okay. They don't want that unless, you know, you can justify it or something like that. They would prefer that you not do that. So they kind of had a rule in place where you can go twice over the guidelines in aggravating circumstances. So here, the state asked for the judge to go twice over the guidelines to 30 years. So, and that was really all the most that the judge could really give, even though the maximum is 40, because of the advisement of the court that you go to 30, or that you only go twice over, he went to 30. It is extraordinary for a judge to go over the sentencing guidelines, but not outside the realm of possibility, but extraordinary. So here, the judge went 7.5 years over the sentencing guidelines, right? He didn't go twice over the sentencing guidelines. He went like halfway to twice over the sentencing guidelines because he found those aggravating circumstances. So even though we don't have the sentencing memorandum yet, I'm going to show you guys the memorandum he wrote finding the aggravating circumstances so that you guys can kind of understand where Judge Cahill is going, okay? Like where his mindset is that already made him want to go over the 15 years, okay? And the thing is, and Artie just pointed it out, no judge likes to be overturned, okay? So the judge went as much as he could. So the judge went as much as he could without fear of getting overturned. Exactly. Because if he had gone over that 30 years or even approached that 30 years, the appellate courts might have said he was moved to passion. He was moved by the surrounding circumstances, the publicity of the case. Maybe he's trying to be an activist judge. You know, they don't want a judge to be moved by passion. And Mr. Nelson was kind of appealing to the judge to say, oh, well, you know, some people will think you're going too low. Some people think you're going too high. The judge shouldn't even be considering what people will think. And something like that, where you go really, really high, might force the appellate courts to look at you and say, well, were you moved to passion? So he was very cautious here, yet still sent a retributive message. Okay, let me finish my thought. Still sent a retributive message that this type of behavior is disdained by the courts. It is abhorred by the courts. Okay. So sentencing, just generally, is supposed to serve two functions. Okay. It is supposed to be retributive. Think the word retribution. It is supposed to punish somebody, get back at them for the bad thing that they have done. And it's also supposed to be reformative. So it's supposed to reform the person from the bad thing that they've done. Send the message to the community that this type of thing is not accepted. So you will have retribution sent against you, but also with an eye towards rehabilitating the person who committed the crime, making them better, right? And it's in rare circumstances where, like states with the death penalty or with life without the possibility of parole, there's rare circumstances in which the court says, this thing that you did is so heinous that there is no way to rehabilitate you, right? So those two things are always at play when you're thinking about a sentence. Then you have to also take the sentencing guidelines into play. Then you have to also take the surrounding case law into play and the integrity of the sentence and the conviction. You don't want your sentence overturned because someone thought your sentence was too draconian. So these were the things that that the judge found as far as the aggravating circumstances are concerned, which informed the 22.5 years, which, guys, again, that is a lot of time. Some people were thinking, oh, maybe he'll get 10 years like Amber Geiger. Two different states, first of all. But secondly, I found that very unlikely. That was the bottom of the guidelines for Mr. Chauvin. But also, she was convicted of, she was basically, the family was asking for her not to really be punished. Let's just put it that way. Okay. So different circumstances. So as a police officer, defendant held a position of trust and authority with respect to the community and its members with which he had contact. The trust placed in defendant included trust that anyone arrested would be treated with respect and only with reasonable force, and that medical needs would be addressed in a timely fashion. Okay? That is his job as a police officer. Defendant abused his position of authority. Abuse of authority is one of the factors. By using force that the jury has determined in returning its guilty verdicts on all 3 counts was unreasonable and exceeded the authority granted peace officers by statute and other law. Specifically, defendant with 2 other officers held a handcuffed George Floyd in a prone position on the street for an inordinate amount of time, more than 9 minutes and 40 seconds, a position that defendant knew from his training and experience carried with it a danger of positional asphyxia. The prolonged use of this technique was particularly egregious in that George Floyd made it clear he was unable to breathe and expressed the view that he was dying as a result of the officer's restraint. In addition, one of the other officers involved in the restraint twice checked Floyd. This is the one with the best chance of an acquittal or a better outcome than all of them. It's the one that checked his pulse and told him to roll him over. After Floyd had been restrained in this position for more than 6.5 minutes, it informed defendant that he was unable to detect a pulse. In addition, the other officers involved in the restraint also twice inquired during the restraint if they should roll Floyd onto his side, i.e. into a recovery position, and later also informed defendant that he believed Floyd had passed out. Thus, not only was the danger of asphyxia theoretical, it was communicated to the defendant as actually occurring with George Floyd, but defendant continued his restraint of Floyd until EMS personnel arrived and prepared to load Mr. Floyd onto a stretcher. We got a $5 super chat from Matt Bond. Thank you very much, Matt Bond. Morning, you spiffy lady. Oh, it's morning to you. Good evening to you. I would think law enforcement have shorter life expectancy because job risk. Why did this lawyer use that when no longer a cop? Why did this lawyer use that when no longer a cop? I don't quite understand. But they do not have a shorter life expectancy. And that's been studied actually. And also, as far as dangerous jobs are concerned, they're not ranked in the top 5 of most dangerous jobs. That goes to nurses and doctors, construction workers, people that like work on like, bridges and things like that. Those type of people have the most dangerous job. When it became clear, even to the bystanders, that George Floyd was in medical distress, was no longer responsive, and had ceased breathing, defendant further abused his position of trust and authority by not rendering aid, by declining 2 suggestions from one of his fellow officers to place George Floyd on his side, and by preventing bystanders, including an off-duty Minneapolis firefighter, from assisting. The failure to render aid became particularly abusive after Mr. Floyd had passed out and was still being restrained in the prone position, with defendant continuing to kneel on the back of Mr. Floyd's neck with one knee and on his back with another knee for more than 2.5 minutes after one of his fellow officers announced he was unable to detect a pulse. The use of a knee on the back of the neck while restraining a suspect in the prone position was not a technique that was a part of any training by the Minneapolis Police Department and was not an authorized use of force. Defendant's placement of his knee on the back of George Floyd's neck was an egregious abuse of the authority to subdue and restrain because the prolonged use of this maneuver was employed after George Floyd had already been handcuffed and continued for more than 4.5 minutes after Mr. Floyd had ceased talking and had become unresponsive. Defendant treated George Floyd with particular cruelty, and he goes into cruelty factors. The children were present at the commission of the offense, which they already talked about in the sentencing. Defendant committed the crime as a group with active participation of at least 3 persons. That was another aggravating factor. And the court, acting as a trier of fact with regard to the sentencing facts, finds that the following facts have not been proven beyond a reasonable doubt. That the victim was particularly vulnerable. So he did not find that. So I have to correct myself on that. In this case, Mr. Floyd's drug intoxication did not render him particularly vulnerable compared to other victims of murder, and restraining George Floyd in the prone position with the weight of 3 police officers on him for a prolonged period of time did not create a vulnerability that was exploited to cause death. It was the actual mechanism causing death. Okay, very interesting. So those were the aggravating circumstances that Judge Peter Cahill found. And that gives you guys some insight into why he reached the decision that he reached. Okay, I hope that helps you guys. I hope that makes a lot of sense. And I think that's pretty much it. You know, once we get Cahill's ruling in, I just want to put up Matt Bond's super chat to thank you very much. $5 Australian super chat. Okay, let me just make sure I understand this. Oh, it's morning in Australia. Duh. I would think law enforcement have shorter life expectancy because of job risk. They don't. And why did this lawyer use that when no longer a cop? I don't understand the last part, Matt. I'm like a little slow. Help me out here. Love the stream. I have to get out and take care of our zoo of the kittens. Yeah, I'm going to get out of here too. Great stream, guys. Merci. Thank you very much, Laurent. Okay, guys, thank you. Thank you. You are all wonderful. I thank you a million, bazillion, trillion times. I hope that I address all of your super chats, but see, I have a $20 sec from Platin's arm. Judge didn't mention parole. No. Okay, before I go, real quick, I'll make this fast. This is easy. Judge didn't mention parole because the judiciary does not determine parole. Parole is under the Department of Corrections. Okay, corrections determines parole. So what probation is, right, is basically the judge will order you'll be on probation for a period of time after you make parole on your sentence. They go to prison, and within the prison, they have their own statutes and rules that determine whether or not someone gets put on parole. Number one, first of all, eligibility to even be considered for parole. I'll give you my state as an example. In my state, it is, if for a crime of violence, you have to have served half of your sentence before you're even eligible. And then once you're eligible, you go before a parole board, and they consider things like your level of remorse, the victim vulnerability, how serious the crime was, and those type of things. If you're still a danger to the community, lipstick on the teeth. They consider all of those things and determine whether or not to release a person on parole. And the person will periodically come back every few years if they're not released their first time around. Then when they're on parole, they begin serving their probation. And the thing about parole is it cuts your prison sentence shorter than what the judge ordered, basically. But if you mess up on probation, you will go back for that amount of time that you should have served. And the judge can put you back in for even more time for a violation of probation. So there are two different mechanisms. Did the judge mention probation, though? I'm going to have to go back and look and see if he's going to be on probation after he gets out of prison. But I would assume he is. But even if he doesn't get probation after he gets out of prison, because I heard him talk about court costs, he will be on parole if they let him out any earlier, unless they make him serve his entire 22 and a half years. But I'll do research, but if Minnesota is anything like Maryland, he would have to serve at least half of his sentence before he's even eligible for parole. And then he goes to a parole board hearing to determine if they're going to release him or not. And not everyone gets out on their first try. So we'll see. That's a really good question. Thank you very much. Okay. Thanks, guys. Thanks, everyone. Thank you. Take care of yourself. Yeah, we'll talk about parole. We'll talk about parole, guys. But I have to look and see if he was put on probation or not. But parole is determined by the prison. Why didn't the prosecution bring up that he had a bad record as a cop, complaints, etc.? They only spoke of how good and dedicated he was. They talked about it in their sentencing memorandum. So they had the things that they argued in front of the court today, but they also submitted a sentencing memorandum ahead of time, and they addressed that. And it'll be interesting to see if Judge Cahill addressed that in his sentencing order. Thank you, guys. Take care of yourselves. Take care of yourselves. Be well. And replay gang. All right. Be good, guys. Bye.